I think we'll go ahead and get started, everyone. Thank you to everyone who is here and everyone who is also online. Good morning, both here in the Dalles and online. To start, I'm Mary Wall, Chair of the Fish and Wildlife Commission for Oregon, and I'd like to call our Friday, July 11th, 2025 meeting to order. We'll do introductions and then we'll start the meeting. So if you will go ahead, Vice Chair.
And should I announce about Commissioner King right now too?
Or at the end? Yeah.
Okay.
Yeah.
All right.
Good morning. I'm Becky Hatfield Hyde, and I live in the Klamath Basin and also near Brothers. And very thankful that you are all here today. It's a huge commitment of your time to be part of this. So thank you.
Good morning. Mark Labhart, and I'm a commissioner, and I live in Sisters. And thank you all for coming today. Very much appreciate it.
Dallas Hall to Freeze, Baker County, Oregon. Yeah, thank you all again for coming.
And Commissioner King is not here, but I think that the Vice Chair is going to say just a bit about that.
Yeah, I think most of you might know that we usually do not have a July meeting of the commission, but we keep it on the calendar in case something like this that's extremely serious, like a petition that is timely, comes before us. And so she is back on the East Coast because she lost her father recently and is kind of tending to some of that business. She does plan on potentially joining later in the meeting. So she called me this morning and just wanted to let you all know that she's been carefully reading all the materials, but she may be joining late. So I just wanted you all to know that, that she takes the issue very seriously, but has had this family issue.
And has, just to add, she has definitely kept up with the pieces as they have come along. So,
and they keep coming.
Yes, yes, they do. Director Colbert, will you introduce yourself, please?
Good morning, everyone. I'm Debbie Colbert, and I'm the director of the Department of Fish and Wildlife.
And Michelle, could you introduce yourself, if you will, and any logistics for people online?
Good morning. I'm Michelle Tate. I'm here to provide support to the commission and the directors so that we can conduct this meeting in a hybrid format. First, I want to start with thanking the city of the Dalles for providing us this facility on such short notice. The Ronde fire interrupted our original plans, and so they worked very quickly, and I'm very appreciative that they were able to provide us a facility. The connection seems to be very solid. I do want to ask folks who are online, we are still, even though it seems like a solid connection, we are still at the mercy of infrastructure. And so if we drop or we have some problems, please be patient while we fix that. Another thing I want to let folks know about our sound system here. There's a maximum of 3 microphones that can be turned on at a time. And when you come up to speak, the long bar at the bottom, if you press that and it turns red, that means your microphone's working. And if it doesn't turn on, then we'll pause for just a half a second and make sure that we turn off so that we have a maximum of three on. And the second thing I want to ask is that, or to let you know, is please help yourself coffee and muffins. We're here for some serious stuff, sometimes snacks and a little caffeine helps us stay focused. So please help yourself. And again, I want to thank you all for being here today so that we can address this issue.
Michelle, Commissioner Spilbrink is saying he's having a hard time hearing this down there.
Yep, certainly.
Okay, thank you.
We'll just take 1 second because we want people to hear today.
Can you hear better now? Excellent.
Better. Thank you, Michelle. And thank you, Michelle, for finding a room. It was very difficult. It's not the perfect room, but we're so grateful to actually have a room. So if you'll put up with the size and that sort of thing. Today's meeting is just 2 issues. One is we're going to very briefly do temporary rules, which we need to do at each meeting, and then we will turn to the petitions at hand. So if we could turn to the director for the temporary rules.
Commissioners, you have 9 temporary rules in your packet. Just wanted to at a high level summarized what's in there. 2 of them are related to wildlife, 7 related to fish. On the wildlife side, I'd just flag one of particular interest. I think we are requiring an additional parking pass this year, Sauvie Island Wildlife Area. It's free. We're limiting the number of entries as a matter of trying to manage some of the impacts to the wildlife there on weekends and holidays, and also some of the safety issues that we were encountering and concerning to Oregon State Police and the sheriff there. So we've done a lot of outreach. We had our first weekend of piloting this new approach over the 4th of July. And I think people are getting used to it and have appreciate kind of the goals that we're trying to achieve, but just wanted to flag that one for you. And we'll do some assessment at the end of the summer to just see how it went, and we'll get feedback from the community, and we'll keep you posted on that. So that, unless there's any other questions on other items.
Commissioners, any questions on the temporary rules? If not, could I have a motion?
I move to ratify the 9 temporary rules set forth on July 11th, 2025 agenda.
Second.
It's been moved and seconded to ratify the 9 temporary rules as was just read into the record. Commissioners, let's do a thumb vote on this one, if you will, please. Unanimous. Michelle, all 5. Thank you. Then we will turn now to the matter at hand, and it's listed in the agenda as petitions to repeal or alternatively amend OAR 635-800-0300. And I would like to just mention a little bit about the structure of the meeting, just so everybody knows what we're planning. We will have staff introduction first, as we almost always do for these issues that come before the commission. The structure will be that we'll have the staff report for 15 minutes. We will have, and commissioner questions as well will be part of that. We will have the petitioning tribes then to address the petitions, and they will have 40 minutes. And then we will have the Confederated Tribes of the Grand Ronde address the petitions, also having 40 minutes. We will take a break and then come back for the response, 15 minutes from each of the 2 groups. So that's how we plan to have it go. We're trying to keep it very clear and very fair, and we look forward very much to hearing from you. We'll all hold our comments for right now. We all have been spending a lot of time with the materials. There's been a lot coming in, including up until, as the chair mentioned, late last night. So we have seen those, we have considered those. We look forward very much to what we're about to hear. So I would ask Davia Palmieri to come up for the staff report. Thank you.
Good morning, Chair Wall, Director Colbert, and members of the Commission. For the record, my name is Davia Palmieri, and I work in the Director's Office for the Department. I'm here to ensure that you have the information you need to consider 4 petitions to repeal or amend Administrative Rule 635-800-0300. So the rules contemplated by the petitions implement the department's 2023 Memorandum of Agreement with the Confederated Tribes of the Grand Ronde Community of Oregon. The rules are short, but they incorporate the entire agreement between ODFW and the tribe by reference. The agreement extends the commission's authority to the tribe's government to authorize hunting, fishing, trapping, and gathering of fish and wildlife by their members in partnership with the department within a defined geographic scope. Per the agreement, the department and Grand Ronde cooperatively use their resources, skills, and influence to advance shared goals for fish and wildlife populations and their habitats. Staff from the Grand Ronde meet annually with W staff to discuss the shared opportunities to make progress on conservation goals and to negotiate the limits and areas of the tribe's ceremonial and subsistence harvest of fish and wildlife based on the best data on population status and trends, as well as the goals of both parties for population levels locally. The petitions that you'll hear today seek to fully repeal the rule, but if not, to amend it to change the geographic scope. The petitions were submitted from May to June of 2024 by the Confederated Tribes of the Warm Springs Reservation. The Confederated Tribes and Bands of the Yakama Nation, the Nez Perce Tribe, and the Confederated Tribes of the Umatilla Indian Reservation. For brevity and clarity throughout the presentation, these 4 tribal nations will be referred to as the petitioners. You will hear from them directly about their arguments in support of the petitions after my presentation. The 4 petitions meet all of the requirements as petitions for rulemaking under the Administrative Procedures Act. By law, the Commission is required to either deny the petition or accept it within 90 days and initiate rulemaking. In coordination with the petitioners, your consideration was delayed until now, which is just over a year, to allow leadership of all of the involved tribes to meet independently and seek resolution. The parties met 3 times, but were unable to reach agreement. An Administrative Procedures Act petition is a request for the Commission to consider taking up a rule concept or not. The Commission will not take any rulemaking action today. Rather, you are deciding whether or not to begin a rulemaking process as requested by the petitions. If the Commission accepts the petitions, the Department will initiate a rulemaking process, culminating in a future decision by this body to repeal, amend, or maintain the rule. If the Commission denies the petitions, no rulemaking process begins today. A denial does not preclude future rulemaking associated with these rules. So I'll focus the rest of my staff report on the requirements of the Administrative Procedures Act and what the Commission needs to consider as you make these decisions. This decision. We've built significant time in this morning's meeting for you to hear directly from the petitioners and from the Grand Ronde. They'll each have 40 minutes to review their perspectives on the rule, and then we'll each have 15 minutes to respond to each other or make closing remarks. After those scheduled presentations, the Commission will take up a decision. I'd also like to note for everyone that the Commission may hold an executive session at the discretion of the chair. Per the Administrative Procedures Act, the petitioners must provide proposed changes and facts or arguments in sufficient detail to show the reasons for amendment, make comment on whether options exist for achieving the rule's substantive goals in a way that reduces the negative economic impact on businesses, and all of the other factors listed here on this slide. The petitions did address all of these factors. I'm not going to dig into the details because those materials are in your packet, and you'll be hearing presentations from representatives of each petitioner in a few minutes. Finally, the Administrative Procedures Act requires the Commission to consider the following points during review of a petition: the continued need for the rule, the nature of complaints or comments received concerning the rule from the public, the complexity of the rule, the extent to which the rule overlaps, duplicates, or conflicts with other state or federal or local regulations, the degree to which technology, economic conditions, or other factors have changed, or the statutory citation or legal basis for the rule. Based on staff's review of the petitions and the situation, we believe the key factors at issue are the nature of complaints received concerning the rule and whether the rule conflicts with federally reserved treaty rights to fish and hunt in the areas within the geographic scope of the agreement. We recommend that the Commission either deny the petitions or accept the petitions based on your interpretation of those factors. Chair Wall, that concludes my presentation.
Then we will move then to the, excuse me, I thought there would be more questions. After W, Josh Newton, if you will come up, please, and also Chair Jefferson Green, I believe, is coming with you to introduce your presentation.
Thank you, Chair Wall, members of the commission. Before I deliver my remarks, it's actually Chief Jefferson Green, the Wasco Tribe. That's okay.
Absolutely.
He's going to deliver a short invocation on behalf of Warm Springs.
Good morning, everyone, as well as all the tribes that are here. This part of the Columbia River is considered Wimaf, and our neighboring tribes also called it Inchiwana, the Big River. And this very part of the land is Winquet. Down the, just a little bit of distance, we have Wasauks, we have other place names. Because of the topic of which we're talking about, our natural resources, our animals, the seasons, the air, our very livelihood. I would just like to offer just a short prayer, just for all of us here, all the tribes, all the leaders, all the generations that we're looking to serve through all of our services. So I appreciate you. Let us also send out our good energies to those that aren't able to be here, those that are struggling through the summer season. And you can close your eyes, you can put your hand on your heart if you'd like. And just so that we're carrying forward in a good way. And I really appreciate you all. Thank you all. Appreciate you. Thank you.
Chair Wall, members of the commission, good morning. As you know, my name is Josh Newton, and I'm one of the attorneys that represents the Confederated Tribes of the Warm Springs Reservation of Oregon. I will be providing initial remarks on behalf of all petitioner tribes. Before doing so, I wanted to recognize some of the other leadership from Warm Springs that's in the room, sort of in that row. We have our newly elected Tribal Council Chairman, Dennis White III. We have Tribal Council Member Alvis Smith III, Tribal Council Member Bridget McConville, Tribal Council Member Jonathan Smith Sr., and we have our General Manager of Branch Natural Resources, Austin Smith Jr. Other tribal leaders here as well, but that's who I will introduce. At this point, I'm going to ask Mr. Jonathan Smith Sr. to join me at the table because he's going to be delivering remarks after me just to keep things moving along. As the Confederated Tribes of Warm Springs leaders have advised us, the matters before the commission today are largely not lawyer concerns. Rather, these issues are tribal concerns. That is, their concerns that are properly addressed by the leaders themselves. These matters center on fundamental issues of tribal sovereignty, self-determination, and maintaining positive government-to-government relationships with the state of Oregon. Nevertheless, there are some lawyer preliminaries that should facilitate the commission's consideration of the petitions to repeal, or in the alternative, amend OAR 635-800-0300. We have prepared 2 demonstrative exhibits showing the objectionable geographic scope provisions of the agreement, which is referenced in the materials we submitted in advance of the meeting, and a copy of the 2014 letter from former ODF Director Kurt Melcher. Now, we should all recognize that the commission is a creature of statute that possesses only those powers the legislature has delegated to it. In short, the commissioner has statutory authority to act in the public interest in managing the state's wildlife resources, which curiously is defined to include fish resources. Oh, is that better? Okay, apologies. So I will say, in short, the commission has statutory authority to act in the public interest in managing the state's wildlife resources, which include fish resources. In carrying out these duties, the legislature has directed the commission to have general knowledge of Indian tribes and their relationship to the lands, water, and natural resources managed by this commission. This includes having knowledge about the federal treaty reserve rights of the petitioner tribes to fish, hunt, and gather in their usual and custom areas throughout the state, as they have done since time immemorial. To be clear, the U.S. Constitution prohibits the commission from violating these treaty-protected rights in the course of its management of the state's wildlife resources. And the commission has no statutory or other authority to adjudicate, interpret, or otherwise determine the treaty reserve rights of any tribe, including the petitioner tribes. And while it has a statutory obligation to adopt policies to promote positive relations with Indian tribes, the commission has no authority to promote its relations with some tribes at the expense of other tribes. Not only does the commission have no such authority, but it is also undeniably bad policy. The notion of intergovernmental agreements between the Oregon Department of Fish and Wildlife and Oregon tribes, including the Ronde Tribe, that aim to co-manage the state's wildlife resources is consistent with commission authority and legislative policy. Petitioner tribes have no quarrel with such agreements if they do not impair petitioner tribes' sovereignty, including their treaty-protected fishing and hunting rights, hunting and gathering rights. And this is where the department's agreement with the Ronde Tribe falls down. The geographic scope of the agreement interferes with petitioner tribes' treaty-protected rights. The most egregious example is that the plain language of the agreement, Section 5, of course it's smaller, and I went to the eye doctor last week too, but it's the subsection 3 that says all lands in Oregon owned in fee by Ronde. The plain language suggests that Ronde could purchase fee lands within the exterior boundaries of either the Warm Springs Reservation or the Umatilla Reservation and automatically be the co-manager of the natural resources on those reservations. We don't believe that's what the commission intended, but that's what the agreement says. In letters submitted to the commission this week, counsel for Ronde Tribe does not seriously dispute this interpretation of the agreement. Instead, the Ronde Tribe's counsel focused principally on disputing the existence of the petitioner tribe's treaty rights in Western Oregon. This is the crux of the issue. There's obviously an intertribal disagreement between petitioner tribes and the Ronde Tribe regarding the scope and attributes of the petitioner tribe's treaty rights in Western Oregon. The Ronde Tribe is attempting to use this agreement to advance its incorrect petition that the petitioner tribes have no such rights. Knowing this, and as long as the department remains a party to the agreement in its current form, the petitioner tribes must assume that the department and this commission have taken sides in this intertribal dispute. agreeing with the Grand Ronde Tribe's mistaken contention that the petitioner tribes do not have treaty protected rights in Western Oregon. This position is untenable for the petitioner tribes regarding their current and future relationship with the state of Oregon. Likely, they will be unable to maintain positive government-to-government relations with the department and the commission unless and until the commission acts in good faith to address their concerns about the agreement with the Grand Ronde Tribe. And for the foregoing reasons, the petitioner tribes respectfully ask the commission to accept the petitions and direct the department to initiate rulemaking to repeal or amend the rule to address their concerns in a manner that's respectful of all tribe sovereignty. Thank you, Commission. At this point, I'm going to turn over the mic to Tribal Council Member Jonathan Smith Sr. And to keep things moving along, if appropriate, I would invite Jeremy Takala from the Yakama Nation to come up, and I will, unless people have questions for me, I will, or maybe there's 3 seats, I can stay here for a moment.
Okay. Good morning. Thank you. Thank you, Chairman Wall and members of the commission. Tukti Karu, good morning. I just want to welcome you all to the home of the Confederated Tribes of Warm Springs. And it's good to see you guys again today. Good morning. My name is Jonathan W. Smith Sr. I'm an enrolled member of the Confederated Tribes of Warm Springs, Reservation of Oregon. I currently serve as a member of Tribal Council, the Agency District. I was chairman when Oregon approved this agreement. I also serve as a commissioner for the Columbia River Intertribal Fish Commission, where we work with other Columbia River Treaty tribes to restore, protect, and enhance and co-manage our treaty-protected fisheries in the Columbia Basin. From 2004 to 2022, I also served on the Fish and Wildlife Committee for my tribe. I'm also a traditional hunter and fisherman, lifelong. I also helped organize the Six Sovereigns Coalition among the Columbia River Treaty tribes in the states of Oregon and Washington in a historic collaboration where we work together to advance the restoration of our salmon and other native fish throughout the basin. As you heard from the opening statement from our attorney, there are serious problems with the MOA before you today, which was passed in a rushed vote that I don't believe the commission expected to happen on that day in August of 2023. The problems with the MOA, which intrude upon our sovereignty, were created by the state, and they must be fixed by the state. Our tribe is legal successor in interest to the Indian signatories of the Treaty of the Tribes of Middle Oregon dated June 25th, 1855. Treaties are the supreme law of the land by virtue of the Supremacy Clause of the United States Constitution in Article 6. The Warm Springs 1855 Treaty reserves legally enforceable rights to take fish at all our usual and accustomed stations in common with the citizens of the United States. We also secure the privilege of hunting outside our reservation on unclaimed lands. The geographic scope of the treaty reserved fishing and hunting rights are not limited to the land ceded to the United States in the 1855 treaty. With respect to the treaty reserved fishing rights, the United States Supreme Court has expressly rejected the notion that those rights are limited to our ceded areas, but instead extend to areas where our people have habitually and customarily fished before and since the Treaty of 1855. Before and since the Treaty of 1855, our people have habitually and customarily fished and hunted outside of our ceded area. In Western Oregon, we have usual and accustomed treaty fishing locations in the Lower Columbia River and its tributaries, including the Willamette River and the Sandy River. Willamette Falls is a particularly important treaty reserved fishery for us. We have a similar treaty protected fishing rights to hunt unclaimed lands in Western Oregon, including the western slopes of the Cascades, as our ancestors have done since time immemorial. Members of the Commission, it is very significant to us that neither the state of Oregon nor the Grand Ronde Tribe have acknowledged the existence of our federally protected treaty reserved fishing and hunting rights in Western Oregon. Even worse, both the state and Grand Ronde Tribe appear to dispute the existence of our treaty protected fishing and hunting rights in Western Oregon. The assertion of the Grand Ronde Tribe and the state that our treaty rights end at the Bonneville Dam defies logic and is difficult to understand. The fish don't magically stop swimming at the dam. More importantly, I would like to remind the Commission that the Bonneville Dam was constructed in the late 1930s, long after the petitioner tribes' treaties were negotiated, signed, and ratified by the United States Congress. The use of the Bonneville Dam as a marker for adjudicated fishing sites was for convenience in co-management by the parties to the United States versus Oregon legal proceeding. That proceeding acknowledges that we have claims west of the Bonneville that we have never relinquished. The zonal approach to fisheries management in the Columbia River was never intended to be an absolute or final determination or the extent of the treaty rights. The Oregon attorneys that participate in that case well know these tribes have always asserted treaty fishing rights that extend to the mouth of the Columbia River and into the Willamette Basin. With respect to the Willamette over the years, we have repeatedly tried to engage Oregon on discussions, and Oregon has refused. Instead of engaging, we now know that Oregon has taken the astonishing position that these tribes do not have any rights in the Willamette system, as demonstrated by the ODFW Director's 2014 letter to the Grand Ronde Tribe, a letter that curiously was not shared with us. Unfortunately, these actions, along with the Commission's approval of the petition before you, continue a pattern of oppression and disrespect of the Warm Springs Tribe's sovereignty by the state of Oregon. For generations, the state of Oregon attempted to oppress the Warm Springs with the fraudulent Treaty of 1865 by saying it limited the Warm Springs sovereignty and off-reservation rights, despite knowing that it was fraudulent. Indeed, the state of Oregon was so aggressive in trying to impose this fraudulent document on the tribe that we had to expend great resources going to Congress to congressionally nullify the 1865 document, primarily to stop the attempts by Oregon to limit our rights. Similarly, due to generations of oppression of our fishermen on the Columbia River, where Oregon continually passed regulations closing our fishery and then jailing our tribal members for exercising their treaty rights, we had to resort to federal court and brought the United States versus Oregon lawsuit in 1968, which is still going today. There, the state again aggressively sought to limit the scope of treaty fishing rights of the Warm Springs tribes, taking the position that tribal members had only the same rights as citizens of the state, ignoring our sovereignty and our explicit reservation of off-reservation rights. The federal court recognized the absurdity of Oregon's position that the tribal members should be limited to the same rights as Oregon citizens when it held that Oregon's position, quote, would not seem reasonable if all history, anthropology, biology, prior case law, and the intention of the parties to the treaty were to be ignored, unquote. ODFW continued the pattern of disparate treatment of Warm Springs Tribe when the Warm Springs negotiated a hunting MOA with the state in 2016 to 2018. The purpose of negotiating the MOA was important to avoid federal court litigation. In those negotiations, Oregon stopped negotiations and then unilaterally reduced the area of the MOA for Warm Springs based on the objections of the Grand Ronde Tribe. Then in 2023, when we raised concerns about the scope of the Grand Ronde MOA, those concerns were dismissed by the state of Oregon. The dismissal of the Warm Springs Tribe's concerns, while it follows a pattern of Oregon's treatment of the Warm Springs Tribes, departs from the path Oregon took with respect to other Western Oregon MOAs. In each of those MOAs, Oregon required that ODFW address concerns advanced by other tribes. This happened with each and every other MOA, but not with the Grand Ronde MOA. Indeed, the Siletz Tribe's MOA was even pulled from OFWC's December 2022 agenda at the last minute due to objections advanced by the Grand Ronde Tribe. To recap, from the perspective of Warm Springs, we see a pattern of discriminatory and disparate treatment of the Warm Springs Tribes. 1, the state of Oregon consistently advanced a restrictive, fraudulent treaty of 1865. 2, generational suppression of treaty rights on the Columbia River, including after the 1969 U.S. versus Oregon ruling. 3, ODFW's 2014 letter to the Grand Ronde Tribes asserting that we do not have any treaty rights west of the Bonneville Dam or the Willamette, notwithstanding the fact that the Bonneville Dam did not even exist when our treaty was entered into in 1855. 4, citing the Grand Ronde Tribe against us as we negotiated a hunting agreement with Oregon in good faith to avoid federal court litigation. 5, departing from the established pattern of those Western Oregon MOAs by approving the Grand Ronde MOA over the objections of other tribes. Commissioners, we have read the letters submitted to you by the Grand Ronde attorney in advancing of this hearing. Our attorneys will address those letters, but I want to make one observation. Grand Ronde appears to be trying to walk the state of Oregon into federal litigation over treaty rights in the Willamette River. We have intentionally sought to avoid that result by filing these petitions. We have learned from the U.S. versus Oregon and in our collaboration with Oregon and the 6 Sovereigns Group that there is a better way. We ask that OFWC carefully consider its actions before it takes the Grand Ronde bait. Finally, we note that from our perspective in 2023, advancement of the MOA to the commission was a rushed vote and was a flawed process. The Grand Ronde MOA has not previewed with other tribes prior to putting it on the commission, as were the other MOAs. Grand Ronde never consulted the Warm Springs about the MOA, as did with other tribes. The online forums Grand Ronde hosted were hastily thrown together after we raised objections about the last note of the MOA, and the lasted mere minutes. It did not even go through the MOA. They were very much like consultation meetings the ODFW held with other tribes, just to check the box events that did not thoughtfully consider the concerns we raised about the tribe. Grand Ronde attorney's letter also mischaracterizes the meetings between tribal leaders. The proposal from Grand Ronde for a 7-mile buffer, for example, was not limited to the western side of the Warm Springs Reservation, but extended all the way around the reservation, at least the way it was presented in the meeting. To be clear, we generally support the notion of ODFW entering into appropriately scoped tribal memoranda of agreement with other Oregon tribes for off-reservation hunting, fishing, trapping, and gathering. We have formally supported in writing the agreement ODFW entered into with the Sluts tribe. Our objection here is more limited. There is a fatal flaw in the MOA before you in the way it allows the Grand Ronde tribe to purchase land in fee anywhere in Oregon and act as a co-manager. It is inconceivable that such a broad provision be included. We trust that you will understand our concerns, see the wisdom in taking the time to get this right, reopen the rulemaking to address the problems we have identified. That will allow us to work on an agreement that is respectful of the sovereignty of all the tribes. Thank you for your attention in this important matter.
Would it be possible just to have a time check with the mic and everything, just so that Mr. Takala has? Okay.
All right, thank you. Nick Maitsky Klathma, and I want to share Bakana Shapatimki Jeremy Takala. Good morning, Chair and esteemed members of the Oregon Fish and Wildlife Commission. My name is Jeremy Takala, and I stand here before you today not just as an individual, but as a voice for my people, the Confederated Tribes and Bands of the Yakama Nation. I am currently the chair of our Fish and Wildlife Committee and also the current chair of the Columbia River Intertribal Fish Commission. My life's paths, son, have been intertwined with well-being of our lands and waters. And it is this deep connection that brings me here today. Like our brother and sister petitioner tribes, the Yakama Nation asks that you accept our petition and direct the department to initiate rulemaking to amend this problematic rule. How we got here. My words today echo what we've stated in our petitions. What we've stated are written comments and what I personally spoke to when I sat before this very commission on August 4th, 2023. Just before the commission cast its vote to approve the contested rule in a split 4-3 decision, how many times has the commission stood divided on such important matters? We hold no quarrel with the spirit of the rule itself, nor with the department entering into written cooperative agreements with the tribes of Oregon. Our grievance lies with the department's process for rulemaking, one that failed to engage in consultation with the Yakama Nation. Our grievances lies with the commission, which offered only a nod that criticisms were heard, but not truly considered or understood. With our petitions and our words today, we hope that the commission truly grasps how their actions have the potential to affect our sovereign interest, including our treaty-protected rights. The roots of our stand. It is vital that the commission fully sees the deep roots of Yakama Nation's opposition, not only to the rule itself, but the rulemaking process as well. First, a fundamental truth, the Yakama Nation was not given direct notice of rulemaking from the department. Is this the unreasonable expectation? It is unreasonable to believe the department should have first sat with Yakama Nation in government-to-government consultation before bringing the rule to the commission for consideration and vote. For over a century, the courts of this land have affirmed again that the state of Oregon must heed and honor the rights woven into the 1855 treaty with the Yakamas. Our people have fought long and spilled sacred blood to ensure our voice is not just heard, but that we hold a rightful place at the table when matters touch upon the Yakama Nation's sovereign interests in and along the Great Columbia River. Let us remember that Yakama people, both today and the days of our ancestors, have always lived along both of the banks of this mighty river in what you now call Washington, Oregon. Our movement, like the river itself, has never held captive by artificial structures like a dam. Our connection to these lands and waters is seamless, flowing freely as it always has. Let us also remember that the Yakama Nation holds federal affirmed rights to fish, co-manage the sacred fishery resource in the Columbia River Basin, not simply because we are indigenous people. No, it is because of the very words of our treaty in the 1855, our ancestors negotiated with the United States to reserve the rights to fish, salmon, steelhead, sturgeon, lamprey, smelt, and many federally affirmed rights stretch from the Great Pacific Ocean up to the Columbia River system beyond the 49th parallel. Such recognition of our treaty reserve rights was no small feat. This long journey is etched in over 150 years of struggle and litigation, a fight to affirm our treaty reserve rights and define their true scope. In 1919, the United States Supreme Court spoke clearly, stating that the Yakama Nation's treaty rights were not held by the lines of Washington State. No, they reached into the lands of Oregon, imposing a servitude upon Oregon soil. Half a century later, the courts in U.S. v. Oregon affirmed that the Yakama Nation, along with our brother and sister treaty tribes, the Umatilla, Warm Springs, and Nez Perce, must be given a fair, equitable share of the Columbia Basin fisheries. U.S. v. Oregon remains one of the longest ongoing court cases in history because it calls for a grand plan. It calls for us as one and as co-equal managers of our shared fisheries resources. The shaping and implementation, these management plans have always brought together our tribes and the states of Oregon, Washington, Idaho to walk a path of coordinated, multi-sovereign partnerships to ensure the unending protection of Columbia River Basin fisheries. Rightfully then, when the department proposed a rulemaking that will touch the fisheries we co-manage as partners, it is reasonable to expect them to consult with Yakama Nation before crafting rules that impact the management of the Columbia River Basin fisheries. Unfortunately, the path the department chose did not include Yakama Nation. They failed to give any notice to the Yakama Nation, let alone engage us in consultation. My words today are not meant to stir old pains. This history is laid before the commission to show the need for department to change its attitude towards Yakama Nation. The department's attitude is embodied by Director Melcher's letter, must be put to rest. The lines drawn by the MOA. Regarding rule itself, our petition is clear in its concerns. These concerns are not simply thought on the wind. There is a deep worry about clashes with our treaty-protected fishing, hunting, gathering rights in our traditional cultural use and usual and accustomed areas that cross paths with the lines drawn by the MOA. Separate stretches of the Columbia River are not managed alone. No, the entire Columbia River system is co-managed. To say it's differently, just as our treaty rights do not end at the Bonneville Dam, our co-management responsibilities do not begin or end at the Bonneville Dam. The MOA, it seems, turns its back on this truth. The MOA brings more people to the landscape, harvesting natural resources under different rules and different methods, and confusion can spread among those who uphold the law about who has the right to harvest natural resources in certain places and what rules to follow. Bringing in new harvests, new managers, and new rules does not strengthen cooperative management of our shared natural resources. Instead, it creates unneeded conflict. In conclusion, we sincerely hope that this commission agrees to take decisive action today to tell the department to remedy the flawed process that led to this problematic rule. Because of our concerns with the substance of the MOA, along with our other concerns regarding the department's failure to consult the Yakama Nation or cooperate in good faith with each of the petitioner tribes, the Yakama Nation urges the commission to act on the petitions and tell the department to initiate its rulemaking. I want to thank you again for your time, for allowing me to speak on this important matter. Thank you, Chair. Thank you, Commissioners.
At this time, I think we'll ask Mr. Smith to give up his seat and ask Corrine Sams from Confederated Tribes of Umatilla to come up. And Aaron, if it's okay to get a time check one more time, I'm trying to, 10 minutes. Perfect.
That's me. Good morning, Chair Wall and Commissioners. My name is Corrine Sams, and I'm an enrolled member of the Confederated Tribes of the Umatilla Indian Reservation. I'm an elected member of the Board of Trustees, the governing body of the CTUIR. I am also the chair of the CTUIR Fish and Wildlife Commission. I currently serve as the treasurer of the Columbia River Intertribal Fish Commission and have previously served as the chair of that commission. In my career as an elected official, one of my primary areas of focus is protecting and enhancing the treaty reserved rights of the CTUIR and the first foods that are essential to my tribe and its members. I am especially committed to restoration of salmon in the Columbia Basin, where I have fished pursuant to my tribe's treaty rights throughout my life. In Article 1 of our treaty of June 9th, 1855 with the United States, the CTUIR reserved the right to take fish in all our usual and accustomed stations and to hunt, gather roots, berries, and medicines and pasture stock on unclaimed lands. This provision was absolutely critical to my ancestors who negotiated the treaty. Members of my tribe have fished in the Columbia Basin for subsistence, ceremonial, and commercial purposes and have hunted, gathered, and pastured livestock throughout their area of traditional use since time immemorial. Our treaty rights are the supreme law of the land, pursuant to the Supremacy Clause of the United States Constitution. The Supreme Court of the United States has acknowledged the paramount significance of our treaty rights and has upheld them repeatedly. The geographical scope of the CTUIR's treaty reserve fishing, hunting, and gathering rights are not limited to the lands ceded to the United States in the CTUIR treaty. Before and since the CTUIR treaty, CTUIR members have customarily fished and hunted outside of our treaty ceded area in Western Oregon. The CTUIR has usual and accustomed fishing locations in the lower Columbia River and its tributaries, including the Willamette River and Sandy River. Willamette Falls is a particularly important treaty reserve fishery. These treaty-protected fishing areas are within the geographical scope of the Grand Round Agreement with the state of Oregon. As we highlighted in our comments to this commission prior to approval of the Grand Round Agreement, as well as in our petition, we are concerned that the broad geographical scope of the agreement will create unnecessary intertribal conflicts between Grand Round Tribe and the CTUIR treaty reserved rights. Our petition to the Oregon Fish and Wildlife Commission is not intended as an attack on our relatives, the Confederated Tribes of the Grand Round, and the CTUIR is not generally opposed to an agreement between the state of Oregon and the Grand Round regarding off-reservation hunting, fishing, trapping, and gathering. We have in fact supported or remained neutral with respect to similar agreements between the state of Oregon and other tribes. Our opposition to the agreement with the Grand Round at this is the Commission's approval in August of 2023. And that is our centered process around the process whereby it was approved. Its broad geographical scope and language contained in the agreement that could facilitate violations of the CTUIR's sovereignty. While our principal issues are with the state of Oregon's action in approving the agreement with Grand Ronde, we have nevertheless worked on a government-to-government basis with our fellow petitioners in Grand Ronde leadership in an attempt to resolve our concerns. And I think we've made strides and we will continue to work together. This effort took the form of a series of leadership level meetings in late 2024 and throughout the spring and early summer of 2025. While I feel those discussions were valuable, they unfortunately did not result in a resolution of our concerns regarding the Grand Round Agreement, and we are therefore moving on forward with our petitions to the Commission. We have significant concerns with the process whereby the Grand Round Agreement was approved. As outlined in our petition and comments to this commission, the agreement with the Grand Round was approved without meaningful consultation with the CTUIR or the other Columbia River Treaty Tribes that have filed petitions. Meaningful consultation could have resulted in a resolution of our concerns with the geographical scope of the agreement prior to its approval. As far as I am aware, the Commission's action to approve this type of agreement over the objection of several tribes is unprecedented. I sincerely hope the Commission will now make the right decision to modify its actions to address our concerns. In addition to our process concerns, we have expressed our significant concerns with and opposition to the broad geographical scope of the agreement and its provisions regarding co-management of resources on Grand Round owned fee lands anywhere in the state of Oregon. The geographical scope of the MOA and OAR 635-8000300 encompasses usual and accustomed treaty fishing areas of the CTUIR, as well as its treaty hunting and gathering areas. The most problematic overlap occurs at Willamette Falls in the lower Columbia River in ODFW Wildlife Management Unit 15, Willamette, and 16, the Santiam. CTUIR members harvest lamb, prey, and salmon at Willamette Falls, conduct salmon fisheries below Bonneville Dam, and harvest smelt in the Sandy River. Under the agreement, Grand Ronde is granted the ability to regulate fishing, hunting, and gathering activities of its members and has co-management authority in all of those locations. We are concerned that conflicts will arise between the CTUIR members and the Grand Ronde Tribe members when multiple parties are conducting fisheries or other activities in the areas. Additionally, the provisions in the agreement stating that Grand Ronde will have co-management authority over fish and wildlife resources on any fee land it owns within the state of Oregon is highly problematic. On its face, this provision states the Grand Ronde can co-manage these resources on lands within CTUIR, ceded lands, or even within our reservation. This is an infringement on our sovereignty and is simply unacceptable. We do not think this is what the Commission intended in improving when they approved the agreement with the Grand Ronde. In our petition, we brought a solution to the table to address these issues. We included in Exhibit C containing proposed amendments to the OAR and the Grand Ronde agreement. These amendments would reduce the geographical scope of the agreement and also expressly state that the agreement does not extend to fee lands within the reservation boundaries or ceded lands of other federally recognized tribes such as the CTUIR. I strongly urge the Commission to consider that adopting these amendments would address the CTUIR's concerns with respect to the geographical scope of the agreement, minimizing the risk of future conflict between the Grand Ronde tribes, the state of Oregon, and the CTUIR with respect to the management and harvest of fish and wildlife, while still resulting in an agreement between the state of Oregon and Grand Ronde that is consistent with the scope of other similar agreements that the state has approved with other tribes. For all of these reasons I have discussed, I ask on the behalf of the Confederated Tribes, the Umatilla Indian Reservation, that this Commission accepts the petitions that have been submitted by the CTUIR and the other petitioning tribes and take action either to repeal OAR 635-800000300 or amend it to be consistent with our petitions. I sincerely believe that a process that involves robust consultation with the petitioning tribes and addresses our concerns can result in an agreement that meets Grand Ronde's needs, while avoiding infringement on our sovereignty and the treaty reserved rights of the CTUIR and the other petitioning tribes. Again, the Confederated Tribes of the Umatilla Indian Reservation is not opposed to the state of Oregon entering into an off-reservation hunting, fishing, gathering, and trapping agreement with the Grand Ronde Tribe. We are simply opposed to the process whereby this agreement was approved and the broad geographical scope. I thank you all for your time and consideration and in allowing me to speak. Thank you very much.
You, Josh. Thank you.
So Chair Wall, members of the Commission, that concludes the petitioning tribe's opening remarks. Thank you.
Thank you. And thank you all for participating and for staying within the time and keeping it within those so it stays quite fair. Thank you very much. Appreciate it. And we will move then to Stacia Martin. And just so everybody knows, we will take a 10-minute break after this presentation and before the responses.
Police Chief Font. Good morning. My name is Stacia Hernandez, and I'm an enrolled member of the Confederated Tribes of Grand Ronde and the Chief of Staff as well for our Tribal Council. I come primarily from the Mercier Holmes and Lino families on the Grand Ronde Indian Reservation, where we've been since our people were forcibly removed from our lands in Western Oregon and the lands covered by this agreement. While it hurts to be here today, we're grateful for this opportunity to defend our agreement with the Oregon Department of Fish and Wildlife. And I have faith that by the end of our testimonies, you will do the right thing and will continue to uphold this body's prior commitment to our people. On our first panel today, I would like to invite Greg Archuleta, Kelly Dirksen, and Colby Dracup.
Stacia, my apologies. I said Stacia Martin, sorry. I heard your right name now. Go ahead.
Hi, I'm Conway Tillicum, like a miss like couple fish tum tum like a miss like on. I just wanted to first welcome you in our tribal language and say happy to be here with you today. I also want to acknowledge that we are in our Wasco and related tribes country here today. And I want to be grateful for the words that Tai Jefferson Green provided today on behalf of everybody here. We're just grateful for that. They are our relatives and we really want to acknowledge that. My name is Greg Archuleta. I'm a member of the Confederated Tribes of Grand Ronde. My tribal families include the Clackamas Chinook, Willamette Tumwater, and Watlallar Cascade peoples of the Columbia River and Willamette River, and Santiam Kalapuya from the Willamette Valley, and Tacoma Shasta from Southern Oregon. And these areas in the MOA that we're focused on today, the Willamette and the Santiam units, of course, directly impact my families and where my ancestors come from time immemorial. We have old stories of how Mount Hood was created, how the first fish and the plants and things came to be of such importance to our people. We have direct connections of ancestral ties to these areas. Jefferson mentioned the name of the Columbia Umoth, and that's the term we related tribes, the Clackamas and the Wascos. And so we have that same term for the river as well as for the lower Willamette River. We call them the Big River Umoth. Wakonkan is our term for the Mount Hood in the Chinookan language, and Nitiyongat for the Malala people for Mount Hood. In our stories, our old stories, you're very fortunate because it's summertime, so we don't tell those stories. That would be pretty long and it'd probably run a time limit pretty quick. But we have stories of the creation of Mount Hood and of a dam that held the water beans and the release of the water. Coyote released the water so the salmon, the fish, the lamprey, all the water beans could be in the rivers for the subsistence purposes of our people. So we have stories, and those originate from the Cascade Mountains. We have stories that tell of Santiam Gap and how it was created on the upper Santiam River. We have places, of course, of creation of Tumwater, Willamette Falls, and how that came to be an important fishing place of our people. And these are places where we did not visit. They were our places where we lived day in and day out. It's the burial areas of our ancestors. And I hope that that as you consider this, that you hopefully keep that in mind, that this is where our people lived day in and day out from time immemorial. And with this MOA, we've had, kind of been locked out of being able to provide opportunities for our tribal members for cultural, spiritual purposes that tie to these places. We have special places all along these rivers. They were used for gaining spirit power, the helpers that would help you throughout your life. They give you powers for things like fishing and hunting. For gambling, we did the stick games. So special powers for those that came from water beings and beings up in the mountains of the Congo Cascade Mountains. So these are really, really, really important places for our people, and really happy that the MOA was approved by the commission here and considered those things. And I hope you will keep those things in mind again as you have to reconsider these issues today.
Good morning, Chair Wall, Director Colbert, members of the commission. I'm honored to get a chance to speak with you this morning. My name is Kelly Dirksen. I'm the Fish and Wildlife Program Manager for the tribe. It's been my honor to serve the tribe for the last 30 years. I was part of the team that put the MOA together. We worked with your staff, other tribes, and our own people, obviously, to develop that plan. We thought we were ready to roll in June of 2023. That was on your agenda. It was pulled and delayed to give what turns out to be the petitioning tribes more time to review that plan. It was back on the agenda in August, and you approved that plan August 4th, 2023. I really wish you could see the power of the decision you made that day. I'm going to have a hard time expressing in words what we saw once that agreement was struck. Our staff worked really, really hard to get a responsible hunting and fishing program on the ground that fall. And when we were ready to issue tags, that was in October of 2023, and our office was flooded. The best description I can give you is that it was really a celebration. We have tribal members that have waited decades to hold a tribal tag to hunt and fish these areas that are so important to the tribe. And just as an example, that's Victor Lomboy. He drove an hour and a half to try to be the first person to get a tribal fishing license. He's competing with his son, Victor Jr., and he ended up winning that. He is the first person to get a tribal fishing tag. And up in the top corner is Gary LaChance, who came to work early to make sure he could get a tag before the day ended. We issued 113 tags that day. A busy day for us is maybe 12. We extended our office hours to be able to accommodate the demand for those tags. But getting a tag is just the start of it. And obviously you do something with that tag. And so for the last couple of years, we have been graciously rewarded with photos, emails, texts, phone calls, and conversations around tribal lands about what it was like to take a tribal tag, go out in these sacred lands and execute that tag to go fishing, hunting in areas that are so important to the tribe. So while I wish I could keep talking to you about the great things that have happened under the MOA, that's not really why we're here today. We're here to talk about petitions and the desire of another tribe or group of tribes to take those rights away. We've heard a lot about federal treaty claims. I'm a biologist, not an attorney, but I do know that federal treaty claims need to be done in federal court and not here with the commission. There are avenues for treaty claims. Our agreement was with you. It wasn't with other tribes. It was with you in the commission. So while I can't talk a lot about federal treaty claims, what I can talk about is petition claims as they relate to the Fish and Wildlife Program that we manage. So these fish and wildlife claims center on two issues: effects to resources and the potential for conflict. And the solution proposed by the petitioning tribes to address these two issues is to remove the Willamette and Santiam units, 85% of our MOA request. Let's start with resources. The petition alleges that an undetermined number of tags would be issued under this agreement for limited fish and wildlife resources, and that would have an impact on the resource and indirectly an impact on the other tribes. So while it is true that the MOA does not
dictate the number of tags. The MOA is not a blank check. Every single year, we work to develop a proposal that covers what we intend to do that year. And we work carefully with ODF&W staff to make sure that our proposal will not have an impact on the resources. In some cases, we have been conservative for our own conservation values, as is the case with native salmon, where we do restrict ourselves on what we could fish for. In other cases, we've addressed state concerns, like in the case of ground fish fisheries off the coast, where the state had conservation concerns there, and we have reduced our proposal in that case. And in other cases, it's gone completely the opposite. ODF&W staff expressed concerns about overabundance of turkeys, and so we are trying to modify our proposal to address that overabundance. The point of all this is that every single year, these impacts to resources are reviewed. ODF&W retains full authority to regulate and protect fish and wildlife resources, and we work carefully with your staff to make sure we don't have an impact. So we now have 2 years under our belt. Let's look at what that looks like on the ground. So this won't show up that well. We've tried bar graphs and pie graphs. The amount that we harvest doesn't really show up, but it's best to just put it in words. Over the last 2 years, for those 2 units, the Santiam and the Willamette unit, state hunters have harvested an estimated 11,412 animals. We've harvested 28, 2 elk, 26 deer over those 2 years. That's 1/4% of what is harvested in those entire 2 units. That 1/4% is critically important to us, but obviously does not reach the level where it's having an impact on the overall resources or anyone else's opportunities. I'd also add that these aren't on top of the state regulated harvest levels. This is not something new. It is folded within what the state issues for harvest. And I think another way to put it in perspective is if you look at ODOT's roadkill figures and you crunch the numbers, there is a really high likelihood that some poor Oregonian has equaled our elk harvest before the end of this meeting. So let's move on to conflict. The petition alleges that by granting the MOA, Grand Ronde would have authority to introduce hunters to new areas that the petitioning tribes are already hunting, and that this could introduce conflict. There are 3 issues I want to address there. First, there is no evidence of conflict, and I'll go into that in a little bit. Second, these are not new areas for us. Grand Ronde tribal members have hunted and fished all of these areas. They've just done it under a state tag. And third, we work very hard to prevent conflict, and I'll talk a little bit about how we do that. And I think one way to kind of start getting there is to look at what's happening on the ground. So this map is a map of the current MOAs of the Western Oregon tribes, all 5 MOA agreements. And if it looks confusing, it is. Every single one of these MOAs overlap. They overlap ceded lands, they overlap usual and accustomed areas, they overlap lands that other tribes own and reservations. And to date, I know of no conflict. We are in regular communication with the other tribes of the MOAs, and we have not heard of any conflicts within intertribal conflicts on any of these areas. I have checked with your staff who oversee the MOA agreements to see if there were conflicts there. There are none. Our MOA is actually overlapped by all 4 other MOA tribes. We are not seeking a petition excluding people from our land, because we don't see conflicts and we don't see a solution being one where you take the rights of somebody else to address a phantom issue. I told you I would talk about how we prevent some of these conflicts. And we meet every year with Oregon State Police, our own tribal police, and officials from ODF&W. And we review the previous season, we preview the upcoming season, and we look to address any issues that are occurring. And I think we've done a really good job. I think that's part of the reason why we can say we don't have intertribal conflicts. I am really proud of the way we have improved our relationship with ODF&W over the last 30 years. This MOA has certainly improved that, was another positive step, but that history is not as bright as it is now. ODF&W took an active role to restrict Grand Ronde's hunting and fishing options. And I want to put some perspective on that no state official in this century or in the previous one did more to restore fish and wildlife opportunities for Grand Ronde than this commission did 3 years ago. As a lifelong Oregonian, I am extremely proud of that. 62 years in the great state of Oregon, and I can say that's the proudest moment I've ever had as an Oregonian, is the day you signed it. I find it abhorrent that we are debating whether we will pull back what has been restored to the tribe. The easiest path forward is to continue with a plan you approved 3 years ago. I think the evidence is clear. There are no resource conflicts. There are no conflicts in the field, and there are mechanisms to address those annually and at the 5-year mark where the MOA is reviewed overall. We have worked really hard to uphold our end of the agreement. We are asking you to uphold yours, and let us continue to do the great work we have been doing together over the last few years. Thank you.
Thank you, Kelly. Just one quick question, because I know you're the best person for this. Can you talk a little bit about the 7-mile buffer that we would impose on our hunters or offered to impose on our hunters, and a little bit about the education we do with our members to make sure they know where they can and they cannot go and what they can and cannot do?
Sure. Yeah, we, to try to address petition concerns, we did look at a buffer around the Warm Springs Reservation using hard boundary lines. Streams, roads, so it'd be very clear to hunters in the field where those boundaries were. That apparently was not acceptable. And I think to answer your question about what we would do with hunters, that 113 tags we did in a day, the reason that's so impressive is that every hunter receives a packet of over 6 pages of maps and regulations, and they have to sign that they understand that. And our staff spent whatever time was necessary to walk every tribal member through those regulations and through the maps so that we wouldn't create conflict. We make it paramount to protect our hunters and law enforcement folks in the field. And I think we spared no expense or time to try to do that.
Thank you. With that, we'll go ahead and turn it over to Colby.
Good morning, ODF&W commissioners, members, tribal representatives, and community members. My name's Colby Drake, and I'm an enrolled member at Confederated Tribes of Grand Ronde, and I'm also our Natural Resources Department manager. My ancestors regularly fished our rivers, hunted in our valleys, and are stewards of this land for centuries. I'm angry and frustrated today to be here and defending our MOA against these petitions to repeal or amend it. This attack feels like a slap in the face to our sovereignty, our history, and our hard work to protect our cultural practices. With respects to Warm Springs and the other tribes, their claims are baseless, lack evidence, and ignore our rights. I urge you to deny this petition and let us keep managing our resources responsibly and with our partners. The petition tribes say that our MOA scope is too broad compared to the other tribal agreements, and that's just not true. Every one of the Western Oregon tribes, CT Clusie, Siletz, Coquille, Cow Creek, they have similar MOAs that allow hunting, fishing, trapping, and gathering with science-based limits set with ODF&W staff, and they are exactly like ours. However, the petitioners are not challenging Siletz, CT Clusies, Cow Creeks, or Coquelles. So why are we being singled out? This is a targeted attack, and I'm fed up with it. The consultation claim is another source point. The petition says ODF&W didn't listen enough, but that's absurd. ODF&W delayed our MOA in August of 2023, pulling it from vote to give Warm Springs, Umatilla, and the other tribes a chance to weigh in. Warm Springs submitted objections before the August vote, and we responded by excluding Willamette Falls and limiting Columbia River fishing. Our MOA, like the other Western Oregon tribes, commits to yearly tribal coordination meetings if agreements overlap. As a resource manager, I've seen our team bend over backwards to respect other tribes' rights. To say we ignored them is insulting and wrong. Our rights are rooted in 7 ratified treaties, including the 1855 Willamette Valley Treaty, also known as the Kalapuya Treaty, which didn't cede our fishing and hunting. Every day I work to manage our resources, salmon for ceremonies, deer and elk for feasts, using science to ensure sustainability for our children and theirs. The petition's baseless claims threaten our cultural survival and our work. The petition tribes have not met their burden under OAR 137-001-0070. No legal proof the vote was invalid, no data showing harm. Repealing our MOA is a betrayal of our ancestors and our future. I'm angry, but I'm still here today to invite our Warm Springs relatives and other tribes to talk and use our MOA coordination rule to share these lands as relatives should. Thank you for hearing me and hearing my frustration today. Please keep OAR 635-800-0300 to honor our rights and our work. Remember, collaboration, not restriction, expands opportunities for all. Hayumasi.
Thank you all very much. Now we'll move on to our second panel. I'd like to invite Bobby Mercier, Jade Unger, and our formal Tribal Council Chairman, Ren Lino, up to testify, please.
Nation Chair. My name is Ren Lino. First of all, I'd just like to acknowledge and say that the Grand Ronde are holding their Veterans Powwow today. So I'd like to acknowledge our people who came here today. This is how much this meant to us. We had to come up, leave our powwow, leave our families, but here we are. And I'd like to acknowledge any and all veterans that are here. So as Stacia said, my name's Ren Lino. I served on the Tribal Council for 21 years. I was voted in 1996, so I'm well aware of the issues here. I currently chair our Fish and Wildlife Committee. But more importantly, not just as a chair, I knew our history. I was 6 years old when we were terminated. So I'm well aware. I'm 74 years old, but my mom and dad are both tribal. So I'm well aware on both sides of our family how unfair termination was and the stripping of hunting and fishing rights to our people. And what for these other tribes, for what they take for granted, we are only trying to catch up. Will we probably ever get there? More than likely not. But this agreement was a step forward in letting the Grand Ronde people move outside of an area, the Trask unit, that wasn't even ours to hunt. We actually hunted across the highway. My dad didn't probably buy a tag for 10 years after termination because he was born there in 1919. They hunted and fished at will. They took care of their people. Most of it was about taking care of and surviving. It was a very poor community. My dad them used to go out when it snowed and it seemed like the snow lasted longer. They'd go out and make sure there was a deer hanging in every garage with our elders. There was only 800 of us there, but they took care of one another. So right now, in moving forward with this, I'm really disappointed because I really don't feel this is the venue for this. I think this is about hard feelings I've been in game Indian politics for a long time. I think there's a lot of hard feelings about casino issues here. We've heard about Willamette Falls. There's venues to take care of them things, but not here. Not in agreements that's going to set policy in Western Oregon, where we do hold 7 treaties. We survived 29 years of termination. There was a saying, I'm a U.S. Marine, served in Vietnam. And there's a saying, when you walk, you got to walk the walk. Our tribe walked the walk. We have had more stuff taken away from us and broken promises than most tribes. A lot of the other tribes on the west side, they got the same thing. They have many broken promises, many broken agreements. Clear back to when we were brought to Grand Ronde, when they said, we'll take care of you. They put us on ground that there's clay, 12 to 18 inches. You couldn't grow anything if you wanted to. You got to go out and hunt and fish. They didn't have a clue where they were going. So realistically, we walked that walk. And this was so much of a positive move. My dad is from the southern tribes. He was Rogue and Umpqua. My mom was from the other end of the valley here, over by Brooks. But basically, they have so we get both sides. I have a family. My dad's sister, her big family, they live over in Lebanon. They retired. They worked for Weyerhaeuser. They hunted that Santiam unit all their life. They retired there. But for them to hold a tribal tag now and be able to hunt that ground means a tremendous amount to them. So instead of pressuring the Trask unit, which is another issue for this commission, and this agreement here helped us take the pressure off of that Trask unit. And it helped us spread our hunters out, and I have kids, the grandkids, and basically it allows them now to go outside and hunt in the grounds that they heard stories about us hunting in. So this thing it's a way of life. When we have Thanksgiving dinner, we have 25 to 35 people, big families. We have a whole plate of deer meat, elk meat. That's the first plate missing, and it's gone. But this thing allows it. It's a way of life. We are not trophy hunters. We are put meat on the table, put meat in the freezers. When we celebrate these things at Christmas, we celebrate them at birthdays. We celebrate them at Thanksgiving. It's just not. It's us. And we need to learn to keep practicing. And these tags and hunting outside of these areas was a huge steps. And I totally respect the other tribes coming, and if they got issues, that's one thing. But this thing is looked at all the time, and it was a great step forward for Grand Ronde. So in closing, I'd just like to say, basically, we've had so many promises broken. I got to ask, which side of history is this one going to be on? Is it going to be on the side that gets broke again? Another promise, another agreement? Or is Grand Ronde going to put this on our list? Or will we get to have something positive? There is no harm. There is no foul here. Our staff showed that. So I can't understand why. And I hope tonight, when we go back to Grand Ronde, we will have a positive thing to celebrate. Thank you.
Thank you. With that, I'll go to Jade.
L'chaim Kanawish Loxta, Jade Unger, Nigan Yahweh, Slustumdum Nikapus Mesli Qua, Kaba Wasco Ili. Just greeting you in our language, our tribe's official language of Chinook Wawa. It's a trade jargon made up of multiple languages from this area, in which our relatives that are here would have likely spoken as well and been able to communicate into the times after contact. And I just raise my hands to the folks that are here. My name is Jade Unger. And also one of the things I said was that I'm happy to be here on the Wasco land, which I also have a connection to in a way, like I'll talk a little bit about that. So I have a lot to say in a short amount of time. I thought I would have a little bit more time, so I'm going to kind of go quickly and just touch on some key things I want to say. My descendancy is Cascade Chinook, the Watlala people. I'm a descendant of Chief Tumult, who signed the Willamette Valley Treaty. The Willamette Valley Treaty is the treaty that is referenced in the executive order by Woodrow Wilson, establishing the Grand Ronde Reservation, establishing the Grand Ronde Tribe, the place where we currently hold our reservation and where our people are centered. I don't say that to hold that treaty up above any other treaty, but to just say that we absolutely have a connection to these areas involved in the MOA. And along with the other treaties that are relevant to our tribe. I have love and respect for our relatives that are here. I'm a Yakama descendant. My ancestor was enrolled in Yakama. I became an actual piece of contention within our tribe for me personally, which I won't go into here today. But the point of saying that is that many of our people have the ability to enroll in multiple tribes here because we're all interrelated. And it pains us to be here fighting with our families and seeing them try to take something away from us. And when we truly, as a people, want to collaborate with them and get along and find common ground where we can all be stronger together versus trying to tear each other down. That's my goal. That's my life's mission. That's what I put my energy towards, and that's what I pray for. And I hope that we can get there someday. But apparently we're not there yet, and there's still a request to take something away from us. I urge this commission to leave what is in place, and to allow us to continue what we're doing. We're not having an impact. You can see it from the data that was presented. There is no conflict. Hunters are respectful in the field. When I go to get lamprey at Willamette Falls and I see my relatives from Umatilla there, we greet each other and we say hello and offer to help each other. I've had that experience. I don't know them. I didn't know their names or remember them, but I know they weren't Grand Ronde, and I know that we got along just fine. And there was plenty of lamprey for people to grab. Now, it is a limited resource. I'm not saying everybody should be able to take everything, but I'm saying that these claims about conflict and about there's not enough and et cetera are not founded, not proven in any of our experience. Another thing that I like to say in the short time that I have is that, as you know, this MOA expressly says that it has no effect on the rights and the privileges of other tribes in the area. And I want to reference the Indian Self-Determination Act, which is self-determination. It's not tribes determining each other. They don't define us and we don't define them. Okay, there's nobody here trying to take anything away from them or infringe on their rights or resources or unadjudicated rights or reserved treaty rights or anything like that. We hold those as well, and ours are important as well. And I just urge you to consider that on an equal footing, that you know, all the things that they said about themselves actually also apply to us.
Thank you, Jade. With that, we'll go to Bobby.
Hello, everyone. I'm Grand Ronde tribal member. I'm one of our ceremonial hunters and fishers for fishing at the falls. And man, I don't know what else to say that hasn't been said already by our leadership here, and that I couldn't see anything that we would do to jeopardize the fish population or the deer and elk population to our relatives. We're not commercial fishing. We have people going out there and getting 1 or 2 fish, if that. And people look at our numbers as tribal members. Yeah, we got like 5,600 members. They do not all live in Grand Ronde. We are not handing out 5,600 tags. You know, there's only a few hundred and maybe 100 or so that even go out and fish. And if there is something there that was to be done, I would say that maybe we should have a seat at Creek Fic to help out, or something that we could be there to help whatever the population disturbance may be. In Grand Ronde, I've been hunting all my life since I could stand up and hold on to the dash with my dad and keep up with him in the woods. And in the Trask unit, it is a scary thing, as I've said in the past. We've gone out there, you get up there 4 o'clock in the morning on an elk hunt, because we do hunt at the same time as state regulations, and there's 4 or 5 trucks from out of town parked at a gate that have been camping there all night long, even on reservation gates. Our reservation is not closed like our relatives. It's open to everybody, and we get up there and it's scary. It's scary. People get up there and they're shooting across the canyon. They don't know where people are at. And so usually opening day, there's none of us locals in the woods. Now being overlapped with Siletz, I get calls from cousins down in Siletz that are telling me they're down in Tillamook hunting. And I'm like, yeah, I know exactly where you're at because we've been restricted to hunting the Trask unit. I know exactly where you're getting elk at. And so my wife is Siletz. Some of my kids are enrolled in Siletz. They hunt under those tags. And, you know, to be overlapping with them, it's all right. We haven't had our problems. And I don't know what else to say. We've ventured out into some of these places where we know our ceded territories are. I come from 3 of our big treaty signers and the head chiefs from Grand Ronde. And, you know, just like I said before, if we would have known the things that happened to us and the things that were coming, they probably would have never signed that first place. Our treaties were ratified in 55. Some others came later. And we've been holding down the Willamette Valley all the way to the Oregon-California border and all the way to the Columbia River under those 7 treaties. So.
Thank you all. With that, we'll invite our next panel up and we'll ask that we save our chairwoman until our rebuttal. So I'd like to invite up Tribal Council Secretary John George and Tribal Council Vice Chair Chris Mercier. I'm hoping I'm close to right. I think I have about 6 minutes. Oh, great. Okay, perfect. We'll tell John he has to stick to the script.
Sushi San, John George Niken, named Tribal Council Secretary for the Confederated Tribes of Grand Ronde. I want to thank you for this opportunity, Chair Wall, commissioners, to Director and Colbert too. Thank you for this time from this. I've had the pleasure of serving on our Tribal Council for more than 13 years. And during my tenure, I have spent countless hours in government-to-government meetings with federal and state agencies and our fellow tribes. I come before you today to talk about the government-to-government meetings we've had with the petitioning tribe since our agreement was adopted in August of 2023. Since our agreement was adopted and signed, we've had 3 intertribal meetings with them. We went into the early meetings with the other tribes with open minds and open hearts. We were hopeful. We believed we would be able to dispel any misinformation and would be able to have open and honest conversations about how we could communicate and work together in a meaningful way. In our first meeting, we provided data on our harvest, reminded them on how we changed our agreement before it was adopted to address their objections, and provide information on how we are implementing the agreement and how we have been following state regulations. We listened with open ears. We went into the last meeting with a proposal aimed at addressing some of the concerns we have heard. We offered to regularly share our harvest statistics, to meet annually, and also prevent our hunters from hunting a roughly 7-mile area or 218 square miles of the Santiam unit around the western side of the Warm Springs Reservation. However, in that meeting, it became crystal clear that the only agreement they would support is one that fully met their demands. Their only solution moving forward was to give them everything they wanted or pay the price. The Grand Ronde people, our own agreement, should not be held hostage. I am disheartened by what I've heard here today. What's taking place before you today is not right. It is not our native way. We deserve to be treated fairly and not like second-class Native Americans. Our agreement was done openly and transparently and through the appropriate public process. We have not violated our agreement. We have stuck to the terms of our agreement and will continue to do so. So the right thing for you today is to uphold your decision and reject the petitions before you today, since the claims they make are not supported by fact. I'll see.
All also probably save. There we go. We'll also likely save our vice chair for a rebuttal as well. So we'll start with him out of respect for your time.
Okay. So we'll just real quick, I take that timer I can see is, okay. Well, I'm not going to get through this. I'll just say, I'm not an attorney. I did go to law school, and there was a phrase we were taught in law school that is, if the facts are on your side, argue the facts. If the law is on your side, argue the law. And if neither's on your side, just pound the table a lot. And I feel like there's been a lot of table pounding in regards to opposition to our MOA. I thought 2 years ago this was a settled matter. Evidently it's not. And I would just ask, I know my time's out, I would just ask that you guys take into account facts, not what could happen, not what if. What if is just a very dangerous game to play. We're not going to buy land in Warm Springs. We're not going to buy land in Umatilla. Focus on what you know and what has happened so far. In a lot of ways, I don't know what to make of some of the arguments against us. When you start citing something in the United Nations from 2007.
Just so you know, we have to add to the other's response time if we take any more.
I would have never known that a Declaration of the United Nations from nearly 20 years ago would enter this discussion. Evidently it has, and I'll save my time for later. Thank you.
We are so thankful for the tribes today respecting their time. Thank you so much for that. We're trying to be really fair with everyone's time today, so thank you for that. We look forward to hear the rebuttals as well.
So we will come back for the responses in 10 minutes. So everybody take a break and come back. And looks like you have a question.
Yeah, can you, I mean.
So small from where you are. The red. Okay, I'll just mention it and that we're struggling to let you know what. Okay.
Okay, sorry, that's why I turned it trying to be helpful, but
Yeah.
sorry, I'm sorry.
And one of the things that we talked about a lot before this meeting was trying to keep things as absolutely fair as we could. And we realized that there are a couple things that we could have done a little bit differently, which is to give you better information about where you are in your time. The timer is here. It's so small that people have to look hard at it. You can notice our twitching when we get close to it, but that's probably not very helpful either. But one other piece, so there is the colored code that helps a little, but we appreciate so much that people are keeping this within the timeframes. We will give 1 extra minute to the petitioning tribes. Did I get that right? Yes. Because the Grand Ronde was 1 minute over in the other part, in the presentations part, and we're just trying to keep it crystal clear. So thank you again, and I think we're ready for. Oh, good. Yeah. We have a commissioner who has joined us. Commissioner King, can you introduce yourself, please?
Hello, can you hear me okay?
Yes.
Hello, joining you from hot, sticky, humid Norfolk, Virginia. I am Dr. Leslie King, Commissioner representing Portland, but I am home back east dealing with some funeral arrangements and memorial arrangements for my father. So sorry to join you late, but I'm glad to be here and glad to see you all.
Thank you, Dr. King. Welcome. So now we will start the clock and go to you, Josh, if you'll introduce your part.
Yes, thank you, Chair Wall and members of the commission. At this time, I'd like to introduce Marcus Sherzad, who's the lead attorney for the Office of Legal Counsel for the Yakama Nation. He and I are going to split the response.
Okay. Go ahead.
Good morning, Chair, members of the Oregon Fish and Wildlife Commission. My name is Marcus Sherzad. I am an attorney for one of the petitioner tribes, the Yakama Nation, but I'm here today to speak in support of the interests of the entire group of the petitioner tribes. The core request today is simple. The petitioner tribes ask the commission to accept their petitions and to direct the department to initiate rulemaking. This rulemaking would be to either repeal or amend OAR 635-800-0300. At its heart, the rule authorizes members of the Grand Ronde to take fish and wildlife on off-reservation and non-trust lands. It also authorizes members of the Grand Ronde to take from Oregon waters. This authorization is tied directly to a memorandum of agreement between the Grand Ronde and the department. To be clear, the petitioners take no issue with either the Grand Ronde or the department's decision to enter into a cooperative management agreement. In fact, the petitioners raised no objection to any other of the similar agreements the department has entered into with the tribes of Oregon. The petitioner tribes could support a properly scoped cooperative management agreement similar to those other agreements. However, this agreement is different. Its geographic scope is overly broad and unacceptable. It's unacceptable because it purports to grant authority to cooperatively manage natural resources in areas where the petitioner tribes possess federally affirmed and adjudicated treaty rights. It's unacceptable because it would allow the cooperative management of natural resources within and proximate to the reservation and treaty lands of other tribes. It is unacceptable because it appears to formalize an arbitrary and artificial demarcation line at Bonneville Dam, mirroring a tired and unsupported position of the department. As you've heard from petitioner tribes and their representatives, these concerns are not abstract. There's particular worry about conflicts within traditional cultural use and usual and custom areas that overlap with areas defined by the agreement. This includes wildlife management, Units 15, the Willamette, and Unit 16, the Santiam. This includes all lands in Oregon owned in fee by Grand Ronde, which could include areas proximate to the Umatilla and Warm Springs reservations and within the Umatillas and Warm Springs treaty lands. This includes major waterways, like the main stem of the Columbia River, the Willamette River, and the Sandy River. And coupled with the September 2014 letter from former Director Melcher, which was directed to the Grand Ronde at that time, it's not unreasonable that the petitioner tribes would find the agreement's language about the Columbia River and the Bonneville Dam to be worrying. For these reasons, the Commission should accept the petitions and direct the Department to initiate a rulemaking process to repeal or amend OAR 635-800-0300. Further, the Commission should instruct the Department to organize a rulemaking process that aligns with accepted principles of tribal consultation. The Commission should instruct the Department to fashion a process that aims to consult and cooperate in good faith with each of the petitioner tribes to obtain their free, prior, and informed consent before adopting or implementing any rule that has the potential to affect their sovereign rights, including their federally affirmed and adjudicated treaty rights. To the Commission, I believe that summarizes what you've already heard, which is included in the petitions, which is included in the written comments, which has been prepared and presented to you by the petitioners today. At this moment, I'd like to turn it to my colleague, Mr. Josh Newton.
Thank you, Marcus. Chair Wall and members of the Commission. Here we are. I assume exactly where every member of the Commission wishes they weren't. And to quote my late partner, Dennis Karnoff, who represented Confederated Tribes of Warm Springs from 1967 until his retirement shortly before his death, this is a heck of a deal. But I want to return to what your statutory prerogative or your statutory remit is. You are the Fish and Wildlife Commission of the state of Oregon. You are not the Truth and Reconciliation Commission. I think what you heard today was a tremendous amount of intergenerational trauma that has been inflicted upon by every tribe represented today by the United States and the state of Oregon. I think that's something that all petitioning tribes can agree upon. I also think it's something that this commission has neither the expertise nor the statutory authority to be able to remedy. So what can it do? Simply, this is an APA proceeding and you have two dispositional paths with which we agree. You can either accept the petitions and direct the department to initiate a rulemaking, or you can deny the petitions. Anticipating that you will have an executive session, I thought it'd be useful to sort of explore those dispositional pathways. What does accepting the petition look like? It doesn't commit you to any particular outcome other than revisiting the issues that have been raised by the petitioning tribes and giving them an opportunity to meaningfully consult with the state of Oregon. That is their right. It's the statutory policy of the state. And there's been some denigration of the UN Declaration of the Rights of Indigenous People. But for those in the know, it's held up as the gold standard of Indigenous people consultation worldwide. And it's founded on the principle of self-determination for all tribes represented. And at its core, it has three principles. Before a state takes an action that can impact tribal interests, they must engage in consultation with the tribe in an effort to obtain the tribe's free, means non-coerced, prior, which means early and often consultation, and that's partly where this consultation fell down, and informed consent, meaning allowing the tribes that are going to be impacted by your action to understand the implications. In 2023, when we were all together in Salem, the petitioning tribes didn't really understand that the plain language of the agreement, as read, says that the geographic scope includes all lands in Oregon owned by the Grand Ronde. Now, we heard today, and there's been some written submissions, there's no present intent to buy lands outside of the wildlife management units that are also mentioned in the geographic scope. But way leads on to way. We'll all move on. You'll rotate off. Someday I'll retire. And if this agreement remains unchanged, the language is a language. And at some point, Grand Ronde could buy land in the Deschutes River Basin. It could buy land here. And it could take the position under the agreement that it has the right to co-manage those resources. Now, if the department understood the implications of the agreement, and so did the commission, so be it. But tell us. We don't believe that you did. We don't think that you intended that. And if that is true, if for no other reason, the petitions have to be accepted for that reason. Because there's no other way to amend the agreement. To amend the agreement, you have to initiate a rulemaking. Now, a couple of other points to make. The petitioning tribes, I don't think you heard today, and you didn't see in any written submissions, any criticism or attack of the Grand Ronde tribe's description of its own sovereignty. I want to contrast that with the written submissions and some of the remarks today. Specifically, the position that there are no treaty rights in Western Oregon. That is a legal question that has not been resolved by the appropriate authorities. And the tribes that are parties to those treaties disagree with Grand Ronde. And there's no dispute that Grand Ronde is not a party to the treaties. So that's an open issue. You cannot approve the agreement or ratify the agreement based on their assertion that our petitioning tribes do not have rights. That doesn't work. If you deny the petitions, you are leaving in place a sovereign injury to the petitioning tribes. If you deny the petitions, you leave in place the risk of the purchase of fee lands within the reservations of the Umatilla Tribe and the Warm Springs Tribe in the future. I think we heard today that there was the offer of the 7-mile buffer. There's not been any specifics that that's limited to the west side of the Cascades. We do believe that the scope, the plain language of the agreement can be read, most naturally read, to extend to the east side of the Cascades. And again, we don't believe that's what the commission intended. So accepting the petitions doesn't guarantee a better outcome, but it creates the possibility for one. That will be dependent largely on Director Colbert and her team and the direction given to her by the commission. It's the only way to make this situation better. Denying the petition essentially tells the petitioning tribes that their understanding of their history and their sovereignty is not shared by this commission or the department. And without waiving privilege and without directly attributing this to one of the tribal leaders, as we were preparing for this, there's frustration on all sides. And our leaders say, why don't they understand this? My grandparents told me this. We were here. You know, the oral tradition is such that by not listening and not giving space for that, you're essentially erasing their own cultural identity. Accepting the petitions doesn't do that for any tribe, but denying it does it for the petitioning tribes. From that perspective, I think your decision is easy. And I think with a new director and with appropriate direction, it will take time to consult appropriately. But I debated doing this, and I know I'm at the end, but I'm looking at Commissioner Hatfield-Hyde, and I have shamelessly plagiarized her since August 4 of 2023. And Commissioner, you had said at that time, as we were working through those difficult issues, you have found in your life that time is not the problem. The problem is the problem. And if you deny the petitions today,
the problem will remain the problem. Thank you.
Thank you. Are there other people from your, thank you. Thank you for staying within the time. Very much appreciated. Let's turn to Confederated Tribes of the Grand Ronde. And you also will have 15 minutes. Thank you very much.
Well, I was in a bit of a hurry last time I spoke, so I do want to introduce myself properly. My name's Chris Mercier. Hi, I'm Nikanim Chris Mercier. I'm the vice chair for the Confederated Tribes of Grand Ronde, and I've been serving on council now for 20 years. I'm going to try and get through this as quickly as possible because we want to save the best for last, which is our tribal chairwoman, Cheryl Kennedy, but there's several points that we kind of feel that we need to rebut. One of them is just because a tribe says they have rights doesn't necessarily make it so. And there are areas that have been covered by the petitioners that have not been adjudicated. They've mentioned like usual and custom areas. That tends to be the province of the federal court to adjudicate those areas. So just it bears mentioning that some of the areas mentioned by the petitioners have not been adjudicated yet. In any case, Grand Ronde's right to hunt and fish at these locations, because of their MOA, does not actually conflict with other tribes' rights to hunt and fish. Hunting and fishing is not exclusive, and there's nothing in Grand Ronde's MOA that prevents other tribes from exercising their hunting and fishing rights in those units. Lastly, so co-management doesn't necessarily mean harvest. Co-management can fall under efforts to improve the resources, and they tie co-management with harvest. So those are kind of the 3 points that we wanted to make sure you guys heard, and we hope they guide your decision-making. Again, like I said in the past, please focus on the facts when you try and make this decision, not what ifs, not hypotheticals. Focus on what we know and what has happened in the 2 years since this MOA took effect. And with that, I'm going to turn this over to someone who's been waiting very patiently, our tribal chairwoman, Cheryl Kennedy.
Thank you, Chris. Can you hear me?
Yes.
Thank you. Good morning, Honorable Chair Walla and members of the Oregon Department of Wildlife Commission, Fish and Wildlife Commission. My name is Cheryl Ann Kennedy, and I have the privilege of serving as the chairwoman of the Confederated Tribes of Grand Ronde for 17 years. I've served on our tribal council for 27 years. I am the granddaughter of 4 treaty signers of tribes that make up the Confederated Tribes of Grand Ronde, specifically for the Willamette Valley Treaty of 1855. My Tyee chief was Chief Wachino, who had villages along the Willamette Falls and lived in that area. In 2023, our people came before you and humbly asked for your fair and just consideration of our memorandum of agreement with the Oregon Department of Fish and Wildlife. We openly shared our stories and talked about the importance of the agreement and what it would mean to the Grand Ronde people, our families, and our community. Nothing has changed since 2023. Over the years, we have shown that we are good stewards of these lands, and we have worked hard to protect and preserve our most valuable resources, including our fish and our game. Since termination and restoration, our people have consistently demonstrated our willingness to come to the table with others, even in the face of opposition, and even when our people are being unfairly targeted and oppressed. Being here today saddens me. Today we are here because there are other tribes opposing our agreement, even some from out of state, an act of lateral oppression by those we hold dear and by those that should know our stories and our struggles, as they've experienced some of the same. When we harvest, we share. That is the Grand Ronde way. The MOA simply allows Grand Ronde to continue these acts of care and cultural continuity. Without it, many of our families face barriers to healthy traditional foods. Since the agreement was adopted and signed in 2023, we have been transparent with our partners and others regarding our MOA and its implementation. We have held firm to our commitments, and we are unwavering in our dedication to our people and this agreement. We are a people of our word and kindly ask you to be true to your word as well. The petitions before you have no merit, and the Commission should uphold its previous decision and decline to accept these petitions. This agreement has nothing to do with treaty rights, and this setting is not the place for those issues to be taken up. This agreement has caused no harm. The notion that our area is too broad is inaccurate. Our agreement is the second smallest within all the Western Oregon tribes MOAs. Over the last 2 years, there have been no recorded conflicts, and the data clearly shows that there have been no negative impacts on the resources. The members hunting and fishing under this agreement were already hunting and fishing under state tags. This agreement has only helped streamline the process for them and given them the ability to reclaim part of their own identities and a true sense of pride. Over the years, we have met with other tribes and made many concessions. We made concessions before our agreement was adopted, avoiding places we knew may cause concern. What was approved in the agreement was much less than we could have asked for, and based off our own ceded lands and treaties should have asked for. We were acting in good faith and being good neighbors. After our agreement was approved by the Commission, we met with the other tribes several times and offered a buffer as a way to help alleviate their concerns about the potential for conflict in the future. At the last meeting, they rejected our proposal outright and stated that there was no reason to meet again, which brings us to where we are today, appearing before this Commission and pleading for fairness once again. I raise my hands to my people for showing up again. In the face of opposition, I raise my hands to them for standing up for our people and for our future as we fight against this grave injustice. While I am not there because I'm recovering from a car accident, I would like to ask all of our Grand Ronde people to please stand. While you cannot see me, I'm raising my hands to you. Hayumasi for being there again. We deserve to be treated fairly. We deserve to be made whole. We deserve to be seen, and we deserve to be heard. Our ancestors died on the lands in our agreement and are buried throughout them. We ceded those lands, and those lands are home. Imagine being invisible on your own land. Imagine your friends turning against you for their own gain. Imagine your identity being taken away and then given back only to be questioned time and time again by people who claim to know more than you about who you are. Nothing has changed since you adopted this rule. The only honorable path forward is to deny these petitions. Please honor your agreement and keep moving forward with the MOU. If the Commission chooses to accept the petitions and open rulemaking, it will set a dangerous precedent, and where these petitions can be used as weapons to challenge each other's hunting and fishing rules. It is my sincere hope that you will honor your agreement with the Grand Ronde. Failing to do so only puts Grand Ronde in a position where it must seek legal redress for breach of its MOU or a Commission decision that is arbitrary and capricious. I ask that you treat us fairly and to base your decision on fact, not fiction. Please honor your commitment and reject these petitions. Thank you for your time this morning. We appreciate your thoughtful deliberation and are available to answer any questions. Hayumasi.
Hayumasi, Chair Kennedy.
Thank you. Is that the end of your presentation? Then what I would like to do is mention a couple things. What I would like to do is just mention a couple things. We have the opportunity to go into executive session, and I at least have some questions for our legal counsel after all of this. And I suspect that other commissioners do as well. So we will do that. I do want to mention a couple things. Several people have said, we're sad to be here. We don't want to be here. I think that's pretty universal in this room right now. The true solutions, of course, sit with the tribes. No one wants to make these kinds of decisions that will leave somebody walking away deeply disappointed. But we have to make a decision at the end of the day, and we will. What's absolutely clear is how deeply, deeply these decisions, whether it's the MOA itself or the decisions that many, many of you have referred to over the years, how deeply those impact people. We put an incredibly high value on our relationship with all 9 of the federally recognized tribes. We are in it for the long haul, the long term, clearly not the kind of time immemorial that you have put, but we are in this for the long term to try to have a path forward that works for everybody and is fair. But it is important to us to have good working relationships with all 9 of the tribes. In terms of the process, we recognize it can be improved. ODF&W recognizes that. We recognize that. We also recognize how deeply these things impact people, and that though past harms aren't on the table, they're clearly they're in the room, and they will always be in the room, and they're on people's minds. We have to make a decision, and we'll do that. I'm sorry for the fact that it won't be satisfactory to everybody, but we will do that based on our respect. And so what we will do now is go into executive session, and I have to do read the thing.
Checking with any other commissioners before you do that.
Would any other commissioners want to give comments now? They didn't. Okay.
Bob does.
Oh, okay.
Yeah, thank you, Chair Wall. Just one thing I might mention is the fact that as far as, the letter, the 2014 letter from Director Melcher, I guess, speaking for myself personally, I would have never said that, when the fish below Bonneville, they're not available, they should not be, part of accessible by the upriver tribes. I guess I would appreciate Director Colbert's perspective on that, but like I say, I don't think it never even entered my thought to say that, okay, below Bonneville, they're not accessible to the upriver tribes, because so much of all the regulation, everything goes into determining who catches what is developed by a consolidated through the tribal members, tribal fisheries from both states, from both departments. So anyway, that's I would have never thought that. I was surprised, as a lot of you were, I think, to see that letter.
Commissioner Spellbrink, commissioners, I guess I would just say, as a new director, and again, it's awkward to kind of second guess, or, it's a letter from 11 years ago. The one thought I have on that is that, as you've heard consistently, the commission and the director have no ability to determine tribal treaty rights. But I also acknowledge that, you are not doing that necessarily through the MOA. So it's not a perfect answer, but just those are the things that come to my mind.
Commissioner Hatfield, hi.
Yeah, actually what comes to my mind is that letter was was inappropriate, with great respect for Director Melcher, who I believe was also a big champion of trying to do the right thing with these kind of agreements. But since we're on that subject, I just want to say that that was not an appropriate letter from my perspective.
And again, that was my personal opinion, not speaking for anyone else.
And seeing no others right this minute, executive session, the Oregon Fish and Wildlife Commission will meet in executive session. The executive session is held pursuant to ORS 192.6602F and ORS 192.6602H, which allow the commission to meet in executive session to consider information or records that are exempt from by law from public inspection and to consult with legal counsel. We will adjourn now, go into executive session, and come back in and restart the meeting. So thank you deeply for all that you have done and for all of the meetings that have happened between now and when we talked last. So we will be back as soon as we can. We're waiting for just a couple people more to come back, and then we'll go ahead and start. And appreciate people coming back and waiting and letting us have the chance to ask our legal questions. So be right with this one.
Michelle, I can't hear. Is that intentional?
Because nobody's talking yet. We're still finishing.
I'm looking at several people talking and I can't hear them. Maybe their mic isn't on?
Commissioner King, we were just talking to each other, waiting for people to come back, and then we will call it into a session again. There's just a couple more people to come back. We're not in session yet.
Okay, thank you.
Thanks. Thank you. We'll come back into session. I would like to take a moment just to mention that to every tribal member and every staff member who has gone through this process with us, we're grateful. We thank you. I wish it were easier. It's not. And we recognize that. We also recognize just how deeply impacted everybody is. And I know I said that one before, but that's what comes across, is how absolutely critical these decisions are, and how long the history is for them. So what we're going to do next is ask questions of staff. Then we will have the commissioners deliberate in public for what they're beginning to think in terms of where to go with this. And then we will make a decision. And we will try to move through that fairly quickly, because we've already taken longer than I think you were expecting to be here. So we will try to make this expeditious, but this is a really critical decision. So commissioners, are there questions to staff that you would like to ask so that we can get into deliberations? And Commissioner King, can you hear us and know that we are, okay,
I'll ask a question. That's okay.
go ahead.
Do we have our cards? My question, Davia, is how did we, when we were doing these consultations to try to come up with these state agreements, determine what tribes we were doing small C consultation with when we were doing that? And I have a follow-up question that asks, what are we allowed to do as it relates to small C consultation?
Thank you, Chair Wall, Vice Chair Hatfield-Hyde. As it relates to the agreements that we've made with the Western Oregon tribes, the comprehensive, I got a lot louder, the comprehensive management agreements that we have with the Coquel Tribe, the Cow Creek Band of Umpqua Tribe of Indians, the Confederated Tribes of the Kuslo or Umpqua Isla Indians, the Siletz Tribe, and the Grand Ronde. Those were bilateral negotiations, government to government, to develop the agreements. The very first one that the commission adopted was between ODFW and the Coquel Tribe, and there was significant discussion about should there be any consultation with other tribes because they are bilateral agreements. And where we landed is that the state policy is for agencies to work with the 9 federally recognized tribes. And so in abundance of caution, the choice was made to notify the other 8 tribes and offer consultation, conversation about the MOA, the draft MOAs via letters to the other 8 tribes and encouragement for intertribal conversations that didn't include the state.
What are we allowed to do as a state as it relates to small C consultation? And when I say small C consultation, I'm thinking of large C consultation is the federal trust responsibility with tribes, federal trust, which is a different whole cat. So that was my question. My second question was, who are we allowed to do small C consultation with? Only the 9 federally recognized tribes in Oregon?
Chair Wall, Vice Chair Hatfield-Hyde, I don't think that there are limitations, not to my knowledge, on what you can do or what we can do. I'll point to the recent creation of a task force on tribal consultation, whose work is ongoing under the direction of Shana Radford in the governor's office. And recently the legislature made appropriations to fund facilitation of that work. And the department is really looking forward to the outcomes of that task force to provide us some guidance on what we can do.
Okay, thank you.
Davia, could you say a bit more about how that would have, in the abstract, how would that have changed what we did in this consultation?
Chair Wall, without the outcomes of the task force on consultation, I can't really speculate on what would be different other than we might have sort of more sideboards, more direction.
I have another question. I have been thinking about the MOA that's in front of us as because the state authority is under the federal and tribal agreements, and the federal and tribal agreements are supreme in terms of what rules, but the MOA is an important piece of what we're doing at the state level. Could you talk about that in terms of the limits, though, that are in there? And when I think of limits, it's things like one thing that got mentioned this morning is that the Willamette Falls is specifically, the state-owned lands at Willamette Falls are specifically not in it. But there are some other limits in terms of you don't get 2 bag limits and those kinds of things. Could you just mention this if so I can think about how narrow this MOA is.
Chair Wald, the MOA under state authority is using the commission's broad authority to regulate the take of fish and wildlife, to extend the ability to issue licenses and tags to the Grand Ronde government to authorize take of fish and wildlife by their members. And so the agreement itself has the limit of the geographic scope. That geographic scope you have on paper, it includes the wildlife management units. It includes, it excludes, and I think that's what you're asking about, what it excludes. It excludes state-owned lands at Willamette Falls. It excludes areas that the state doesn't have jurisdiction over, like the Washington side of the Columbia River. And I have to look at my document for the other exclusions. In terms of bag limits, we talked earlier about, or I guess Kelly from the Grand Ronde talked about the annual meeting where we determine the limits and areas. So the MOA itself is a framework that allows Grand Ronde to authorize the take of fish and wildlife using the state's authority. Every year, the department and Grand Ronde must agree on what the limits will be on their take, specific to every species that they might have an interest in. We negotiate every year on what that take can be, limited by the policies of the state. In terms of bag limits, the only limitation is specific to the Columbia River, where a Grand Ronde member may only have one bag limit, be it under a Grand Ronde tag or a state tag. It's not limited in other areas of the state. Does that fully answer your question?
I think it does. Yes.
Okay, let me check my geographic scope document, if I could read that one. Any area on the Columbia River, upriver, or Bonneville, the summit of the crest of the Cascades, and any property held in trust for another federally recognized tribe. So those are the exclusions from the geographic scope.
And in terms, just one other piece, in terms of other exclusions, this is only subsistence and ceremonial.
Correct.
Is that right?
Correct.
Okay.
There's no commercial harvest authorized under the framework.
Okay. Thank you. That helps. Do other people have questions, or you? I had one other just in terms of, and this is history that I don't know because I wasn't in the negotiations, but in terms of, there is the past and we've heard a lot about the history that is in the past, but now we're in the era, if you will, of MOAs. Where does this one fit within that interplay of MOAs and moving forward with MOAs and trying to get things right or get things figured out better through MOAs? And that's not an easy answer to give, I would assume, but it's evolving, to say the least, in terms of these MOAs. Is this one like the others? What did we learn from the others and put into this one? Because we also have to think about others in the future or whatever.
Chair Wall, if I'm understanding your question correctly, the MOA between ODF&W and the Grand Ronde is substantially similar to the MOAs with the 4 other Western Oregon tribes.
Thank you. Commissioner Hatfield-Hyde. Chair.
I would just say, though, maybe a question would be, what made this MOA with Grand Ronde different than the other agreements that we, approved? Is that we had maybe other tribes disagreeing with pieces, but much of that work was done before it came to the commission. And with this agreement, I would say there's been a lot of static, right? That's why we have a petition here today, is so those other agreements, we do not have other tribes at our doorstep about those agreements today, like we do with this, right? Would you say that is what makes this different than those other agreements that we did?
I wouldn't say, Chair Wall, Vice Chair Hatfield, I wouldn't say it makes the agreement different. It makes the situation different.
Makes the situation different.
Seeing no other questions and Commissioner King's hand is not up, then let's begin to talk about deliberations. And it looks like you're ready, Commissioner Lamhart. Would you like to?
Thank you, Chair Wall. It's with it's with a great deal of anxiety in me about where we're gonna go from here. So I'll just say that right up front. I'll also say up front that when I get to the end here, I'm open to ideas, but you'll kind of see where I'm going as I go along. I want to thank everybody for being here. Thank you for caring. Thank you for showing up. Thank you for your testimony. Thank you for your hard work behind the scenes to get to where we are today. I wish we were at a point where we were not going to upset, like the chair said, one group or upset somebody else and somebody else walks out of here with a win. So maybe we won't get there, but we'll see. So I have read all of the APA petitions. I've read all the testimony that you've provided. I pretty much would say that the majority of the testimony that folks gave today were a summary of what was in your written testimony and what was in your APA petition. So I did pick up some new things, nuances there that I did want to talk about just a little bit. So my comments are in writing, but it's based upon information that most of you provided and then summarized with your testimony today. So on August 4th, 2023, the Oregon Fish and Wildlife Commission approved the final memorandum of agreement and related administrative rules governing off-reservation and non-trust land hunting, fishing, trapping, and gathering with the Confederated Tribes of the Grand Ronde Community of Oregon. This agreement is consistent in scope with several other tribal MOAs the Commission has approved in recent years, including the Coquille Tribe, 2022, the Cow Creek Band of Umpqua Tribe of Indians, December 2022, Confederated Tribes of the Coos, Lower Umpqua, Siuslaw Indians, June of 2023, Confederated Tribes of the Siletz, 2023, Confederated Tribes of the Grand Ronde Community of Oregon, August 23. Additionally, in 2018, a prior commission approved a similar agreement with the Confederated Tribes of the Warm Spring Reservation. And some of these MOAs, as we saw on one of the maps that was showed, have overlap in geographic area among the MOAs. One MOA overlaps into another MOA. So we do have overlap that has occurred. Following the approval of the Grand Ronde MOA, the Commission received 4 Administrative Procedures Act APA petitions requesting that the MOA be repealed or amended. It's important to clarify, APA petitions are procedural mechanisms allowing the public to request rule changes. The purpose of today's meeting is not to amend or repeal the Grand Ronde MOA, but rather to determine whether the Commission wishes to initiate a new rulemaking process in response to the petitions. At the request of the petitioners, the APA process was temporarily paused to allow for direct discussions between the petitioners and the Grand Ronde tribal leadership. We didn't have to do that, but we thought that was a good idea to slow the process down and see if we could reach some kind of an agreement between the parties. Those sides met 3 times, as many of you heard today. They met 3 times, and in my opinion, it was in good faith. They were unable to reach a resolution. This outcome is very disappointing to me and is now up to the Commission to determine the next step. Regardless of the decision made today, I am concerned that the litigation may follow as one party is likely to challenge the outcome, a result that benefits no one, in my opinion. The verbal and written testimony presented today by the petitioners closely reflects the written materials the commissioners already reviewed in the 2023 testimony where the commission approved the Grand Ronde MOA. The petitioners raised two central concerns. One was not brought up today, and I'm going to discuss that, but and it is the commissioner terms. Petitioners argue that the commission's August 2023 vote was invalid because two commissioners were serving beyond their appointed terms. However, Oregon law 496090 allows commissioners to continue serving until they are reappointed or replaced. The Oregon Department of Justice has confirmed that this practice is legal and valid for all Oregon state boards and commissions. The second major concern is sovereignty and treaty rights. Petitioners claim the Grand Ronde MOA infringes upon their sovereignty and treaty reserved rights. Specifically, they request the commission to remove the MOA, or repeal the MOA in its entirety, or amend it to include amend it to exclude the Santiam Willamette Wildlife Management Unit. It is most critical to note that this MOA, like those with the other 5 tribes, is an administrative agreement under state authority, not a recognition of modification of treaty rights. It grants regulated access to hunting, fishing opportunities for the Grand Ronde members in the same way as the other tribal MOAs. Nothing more, nothing less. The MOA rule language in OAR 635-800-300 makes clear in section 3, I'm going to make this really clear, quote, no additional tribal, legal, or treaty entitlement is created, conveyed, implied, or diminished, nor is any existing agreement, treaty, or court decree modified. Section 4, nothing in this MOA shall be construed as affirming, recognizing, or limiting the rights or claims of any other tribe, preventing agreements with other tribes, affecting the tribe's legal rights, including treaty or aboriginal rights. In other words, I've been clear. Similar languages exist in the other approved MOAs. The MOAs remain necessary to support the state to government relationships with the Grand Ronde tribe. Like previous MOAs, it applies narrowly to off-reservation and non-trust land activities. The concern raised in the current petitions mirror those already considered in 2023. Many of you raised the similar concerns that we did when we reviewed the original petition in 2023, and now we're hearing them again. The commission concluded at that time that the MOA does not create or expand treaty rights. Petitioners identified 3 areas of potential conflict. 1, Federal Reserve treaty rights. The MOA does not alter or affect any treaty rights. It is clearly stated in both the rule and language and the original 2023 decision. The conflicts with other tribal MOAs. The 2018 Warm Springs MOA states that off-reservation activities outside its scope are subject to state regulations. The Santiam and Willamette units were not part of that agreement. Fishing rights below Bonneville Dam. No court has adjudicated this issue. The Grand Ronde MOA was specifically revised to ensure that fishing conducted under it on the Columbia River is regulated identically to non-tribal recreation fisheries. So I hope we set that issue aside. That has not been adjudicated. For example, the MOA language ensures that the Grand Ronde members fishing on the Columbia River may only do so under identical regulations as recreational anglers. A single bag limit applies, even if a person holds both a tribal and a state license. The Commission has clear legal authority under ORS 496012, 496138, and 496146, and ORS 19110 to enter in agreements with tribal governments and regulate wildlife-related activities. The Commission does not have the authority to define or alter any treaty rights. That responsibility lies solely with the federal government. So, conclusion. Based on the review and discussion, I offer the following observation. There remains a clear need for the Grand Ronde MOA and its associated rule consistent with past Commission action. The concerns raised in these APA petitions are not new. They echo previous arguments the Commission has already considered and addressed in August 2023. Allegations involving treaty rights lie outside the Commission's jurisdiction and should be addressed through federal channels, not state rulemaking. I don't believe accepting the petition or delaying it. I'm calling it kick the can down the road. So we could deny the petition, and then it's up to the party that lost to decide whether they want to incur a court action. If we decide to accept the petition, we can, what I call, kick the can down the road, and potentially, if we can, enter into a small C consultation where we can see if there's an opportunity while we're going through the process to see if in fact we can reach an agreement that is acceptable to the 4 petitioners and the Grand Ronde tribe. I'm not confident that that'll happen because we've tried 3 times now to do that. We delayed once and we had 3 meetings with the petitioners and we didn't get anywhere. So I don't know whether the fear of another rulemaking process would bring the parties to the table to try to figure out something that both parties can live with. I'm willing to do that if we think we can. If we're going to just kick the can down the road and go to a rulemaking, and then months from now we have to make a similar decision. We do a rulemaking and somebody wins and somebody loses. So if I can get assurances from the petitioners and the Grand Ronde that we're willing to go to the table for the 4th time and see if we can work something out, I'm willing to kick the can down the road. But if the petitioners say, nope, we're done, we've had it, we're holding our, we're staying our ground, then I would say deny the petition, move forward. We've already adjudicated it through the commission process and move ahead. So I'm leaving the door open. That's my opinion. So.
Yeah. Well, the first thing I want to say to all the Native people in this room is that I'm sorry. I am sorry we are here. This is a worst outcome for me to have tribes in this state and outside of this state in disagreement with one another, and maybe because this commission did not take the time that it needed to take to work these things through in a way that made this agreement similar to the other agreements that we brought. And what I'll tell you is I'm from Klamath. I'm from the Klamath Basin. So when we started doing these state agreements, I didn't understand them at first because I'm used to the large C consultation and the relationship that tribes have with the federal government and their treaties and how those treaties affect things like hunting, fishing, gathering, usual and accustomed places. So what we have here is, I think, tribes that are operating from very different treaties. That doesn't make one tribe better or lesser than another. It's just part of the, frankly, dramatic history that brought us to this place that is not so great, right? And I think what we had hoped with these agreements was that we would be making things better for tribes, not making things worse, not taking the people who I feel are the foundation of this state, which is our tribes, and creating more conflict. That is not, I think, what anybody wanted. So I feel like a lot of what Commissioner Labhart said about what the scope of this state agreement is true. But I don't think we gave this time for people to take the time to consult And frankly, we, in my mind, needed to small c consult as a state, also with the Yakama tribe, also with the Nez Perce tribe. I think it was not acceptable. I think it was rushed. I also am used to being around tribal Indian rights settlements. Guess how long they go on? Decades. This agreement came up and was how many months, Fabia, from when we started to meet to when we came to the table?
I'd have to look that up.
Yeah, but within a year. So I guess what I'll tell you is, as these agreements were coming to us, the previous agreements with all the Western Oregon tribes, I kept thinking, wow, these agreements are coming at us really fast, and they're really positive, and they're a good thing. And I want them to happen, but it's odd for me because I'm not used to agreements like this happening so quickly. And part of it was me learning about small c consultation, which is very different than consulting with the federal treaty rights, with the federal trust responsibility. When I read all of everybody's arguments, I can see the petitioning tribes' fear because they have spent 100 years trying to protect their concept of usual and accustomed places. They have federally reserved hunting and fishing rights written into their treaties because of the way those treaties were put together historically. I don't think we gave those tribes the time to take a deep breath and say, okay, this might be okay. It might be okay. Let's give this a little time. Let's have some time to talk this through. Let's have some time to understand what the state agreement is. Let's have some time to consider whether it has any impacts at all on various treaties. So that's where I'm frustrated with us as a commission, because what basically happened at that meeting is we were scrambling. We were scrambling. We didn't know what to do. We're trying to do dumb things like, hey, maybe the tribes could talk to each other today and get along better, when that's so insane because you have to go back and talk to your councils, and in some tribes, your entire general council, to make these kind of really important decisions. So I got 700 sticky notes here, you guys. We have an opportunity here still to try to do something good, but it depends on the people in this room doing something good with each other, right? It's you all. And these things go back, right? We heard it today. There's issues around casinos. There's issues about these. God, we need you guys. We need you guys to be strong with each other as tribes. We can't fix that. So I guess in some ways, I think Commissioner Labhart may be coming at this a little differently than I am. I'm coming at it, accept the petition and work. Again, take some time to do actual small c consultation with tribes that are in this room that were not consulted. That is unacceptable. There are not, these tribes, these issues do not just affect the state of Oregon. They don't. We might wish the Columbia River and these issues are just about the state of Oregon, but they're not. There's other tribes have other interests in the Columbia and these issues that we didn't take the time to listen to. Why? Why don't we take time to do it right with each other as neighbors? Why wouldn't we? Why are we in a hurry? Why do we have to do an agreement in 8 months? Why can't we build a new future together. So I am, strongly feeling like we felt good and we did a lot of agreements that had support. The other agreements had support. This one didn't. It wasn't ripe. It wasn't ready. So that's my thought for the moment.
Thank you, Chair. I also want to start with just noting that it's been said that, we're here under unfortunate circumstances, but I disagree with Mr. Newton in saying that doesn't mean that I don't want to be here. I feel very honored to be here and to hear what you all had to say. And I feel very humbled by that. So thank you. The next thing I want to say is I also think that today we heard many truths, and I don't think that we should think that one truth diminishes the validity of another truth. And I think that that is really kind of at the heart of the problem today. And, I agree with a lot of what Commissioner Hatfield-Hyde said. She said in more inspiring words than I will probably say. But I think we're in a position where both of the parties here are not wrong. You both are right, and both not wrong. And I'm looking at this in a somewhat unique scenario. I was not here back in 2023. So how do I approach this now? Where are we at today? And what can I look forward to going forward? And I am often finding myself kind of optimistic continually, but perhaps to a fault to some. But I also see this as an opportunity for us to go forward and to watch something beautiful come out of this. I think today, at the moment, tonight, it will be hard for some, and it may feel like some of the decisions being made are at the disposal of others' rights and others' thoughts. And I just want it to be known that this is not easy. And I agree that, Mr. Newton also said that we are not, as the commission, adept or armed with a way to facilitate these issues. I certainly do not feel that way. I want to look to you all to be leaders with one another, and to teach us how we should be working in the state of Oregon with the tribes as partners, as collaborators, working for a better future for our natural resources. And I believe that that future is possible, and it is not easy, but I think that we will get there. And we will get there just by the presence of you all here today. You are still fighting for the same things that you have been fighting for generations, and I respect that. And so I just want to say all of that and let you know that I have hope, and I think that's something that can become better out of this. And for that reason, I think when I look at this, I agree with Commissioner Hatfield-Hyde. We have the opportunity to go back to the drawing board. The way that we went through this the first time was obviously broken because we are here today. So how do we go back and refix that? And so I'll end with that. Thank you.
Thank you, Chair Wall. Yeah, I second everything that's been said here. I think, like I say, when I, read the petition, I thought, wow, that's good. And then I read the response. I thought, wow, that's good. And a couple things we had clarified here, I think, in executive session was that accepting the petition does not nullify any of the MOA's current provisions. It just says, let's continue to develop a path forward to a proposal that all parties can accept. I want to reemphasize that. I think I can speak for most of us here, myself for certain, that there's no intention of pursuing any major changes to the current MOA that will reduce tribal opportunity. You testified to that the last couple of years, what you've experienced, and how it's benefited. And I don't see anything here that would reduce that tribal opportunity that you've had in the last couple of years. I won't say anything else than that, but I just, like I say, appreciate all the input here today, and we'll make sure, do our very best to make sure that you have as much opportunity as possible.
Is it my turn? Or do you want to go? Can you guys hear me okay?
Yes, it is Commissioner King. Chair, while your microphone is on, I don't think she can hear you.
Sorry. Yes, go ahead, Commissioner King.
Thank you. I always feel there's a weird delay. I can never really tell what's happening. But thank you, Chair Wall. And again, to all, sorry for missing the first bits. I would have rather been here than listening to my family telling me how much of my hair has turned gray. I actually thought of Commissioner Hatfield Hyde about how she was accusing people of looking old. But no, I struggled with this one at, gosh, 2 years ago now. And I think it's still hard today, because the thing that I always bring, try to always bring to this commission, to this department, to kind of how I look at the world, is that human dimension. And so much of what we're seeing is weathering effect and intergenerational trauma, and just, a whole different sense of time and a whole different sense of timing, a whole different view of the world, meaning seeing the world as a circle instead of a line, those sorts of things. And to get to that place sometimes takes, as Commissioner Hatfield Hyde, sometimes it takes decades. It's not going to be 8 months, that's for sure. Not going to be a couple years. It's not going to be just a few meetings. And I think when we're talking about trauma, and I can tell you as a doctor, and that's one of the reasons that psychedelics are kind of coming to the fore, is trauma literally rewires your brain. It is an actual, you can prove it on MRIs and all sorts of things. And the reason psychedelics seem to work is that it breaks all that circuitry and allows you to get a new set of wiring, essentially, just speaking in layman's terms. So not saying we should all go and take psychedelics, but the point that I'm saying is the only way through trauma is just that, it's through it. There is no getting over it. There is no going around it. There is no there is no, it's only through. It is only through. And to me, that is what these kinds of discussions, these kinds of deliberations, even in executive session, like being able to have question and answer, it allows a way through. It allows more consultation, whether it's big C or little c. It allows more of an attempt to come to understanding of people who see the world so fundamentally different, to be able to communicate in the same language, because that is so much of what we saw 2 years ago. Like that level of conflict meant we did not understand each other. And that is kind of what I would like to avoid. I would like to stop with this coming at each other in anger. I would like to stop with this blaming. I would like to stop with who got a bigger piece or smaller piece. One of the things, being back east, and dealing with tribes when I'm back here, like people who are descended from slaves and people who are descended from indigenous folks, we've kind of come to a detente in that we're not going to sit there and say which is worse, like being taken from your land or having your land taken from you. We're just not going to have that pissing contest. So we've just got to come at it in a whole different way, and just sit and talk and learn. And I think my biggest takeaway from all of that, and it was a very long meeting 2 years ago, but my biggest takeaway was from the very start. I think one of our first public comments was from Nez Perce. And I remember just being gobsmacked and just jaw-dropping, thinking, we did not even consult these people. Like, we didn't even consider them. We didn't think of them. Here was this beautiful guy. I remember his like beaded necklace, and it was all about, oh, well, they're a different state, so like somehow they don't count. And it's a fundamentally different way of viewing the world, and that's what I realized that we didn't do. And here's hoping by, say, accepting this petition and everybody come back and still try and work it out, that allows us to get there, to us coming together with these fundamentally different views and come to some kind of compromise. It's not ever going to be perfect. No compromise is, but it most certainly will be better than us being at each other's necks. That's what I don't want, because that serves nothing and no one. So, and I think, you know, by talking it through, we can get through. Is this narrow? Does it involve feds? Does it not? Why? What is so different that, how do you see the world so differently than me? The only way is through. So that's what I would support, you know, at least having additional, not just consultations, but conversations to get us to the through. So that's all I have. Thanks.
Thank you, Commissioner King. I'll take a moment to talk a little bit about where I'm landing, and I find myself in a somewhat different position than some folks have talked about. What I absolutely agree with is the point about both sides are right, and there's a lot of truth in this room. I appreciate that people did all of the meetings, and I recognize that there wasn't a solution. I don't find myself agreeing that there wasn't time spent on this. I think it was it's been almost 2 years not to the day, but it's been 2 years since we had this MOA put in place, and we haven't come to a solution that is different than what we have now. And there are some objections I heard about today that I think are absolutely important. They're huge. The objections that the four petitioning tribes had, they're persuasive. So were the comments about the impacts of the times when the consent decree was in place and the different treaties that people have and trying to manage under so many treaties. When I look at what we're doing, it's figuring out, and I think this is so important, it's figuring out how to share state authority. And that's what this MOA is supposed to be about. And so when I look at it, this vote is whether to continue that MOA and to continue this experiment, if you will, because they're all sort of experiments in how to share state authority. It's a huge step. It's a big deal. And I applaud the tribes and the staff for coming to this MOA with the ones that we have in place so far. The reason I asked the question about the MOA being and what its limits are is it does seem limited to me. It's state authority. It's very important to share it, but it's limited, and it's pretty tightly limited in terms of what it can do and what it will allow. I do recognize why people have some fears about certain language in it, but I think we could look at that. And it's not the top of my list, that particular fear that the MOA will open doors that we don't want open. I think the more important thing is that we are sharing state authority, and we tried to figure this out. It's an approach aimed at improving on what was before. And one issue, and we keep coming back to this one too, is what's fair. And it troubles me some that we would add a requirement for everybody to agree to an MOA after the fact. So what would work better as I look at it, is we have an MOA that clearly is creating problems. So we have an obligation, an opportunity. Where I see the opportunity right now is leave this one in place. It's already in place 2 years. We'll review it in 3 more. It's got a 5-year review. But in the meantime, we need to be on a path to figure out how these MOAs can happen and be reviewed, and the same standard applies to everybody. But the standards are there before you go into the discussion, not applied after, and then it gets to reverse the, if you will, the MOA. So that's where I find myself. It's deeply troubling to even, have to deal with this. But I don't think we should just hand it to staff and say, try again, when in 2 years we haven't fixed it. So I would appreciate leaving it in place and swear, our obligation going forward is the commission, the staff, the governor's office, the tribes need to figure out how to do these MOAs so we can share state authority. That's the question that's on the table, I think, at least as I look at it. So that's where I end up. So we have, looks like you have some, yeah.
Yeah, I would just, Chair Wall, ask a question of you. I understand that you are not interested in kicking this back to staff. But I totally lost my train of thought.
We'll give you a chance to ask it in a minute. And
I just lost it, people. That's what you're dealing with here.
Well, and I think that Kit, in terms of, and maybe this will help you remember what your question was, I think that kicking it back to staff, the part that that I think is most important to kick back to staff is how do we as a collective, how does the state carve a path forward so that we don't get into this problem and identify what needs to be in what level of agreement and that sort of thing is before people enter these. It just feels wrong. It just feels like I just can't get to the point of taking back the MOA because there wasn't complete agreement when we, after 2 years, we still haven't gotten there. So, well, does that help you remember your question?
Yeah, I guess what I'm saying is that that seems fairly, I mean, I'm aspirational as well. I'm a depressed optimist. But what I will say is that's a burden for the tribes in this room to say, oh, let's all sit around and figure this out in a way too, right? Like someday in the future, we'll figure out how to get through this. And I actually feel like this agreement was very different because we didn't take long enough, Mary. And then when you put the tribes in a position, which we put them in because we made a decision way too hastily, we put them in a position of having to decide whether they're going to work with one another on this. I think it's okay for us to step back and say, maybe we were in the wrong here and we can fix it. So it's like chicken and egg. I feel like both you and Mark are saying, yeah, let's in the future, once there's something that the governor's office has going, we'll revisit or something. And this to me, accepting this petition right now feels more deliberate. Like, no, we're gonna bring some of those tools to the table, but we're gonna address the fact that we didn't get this one right. And that's not negating the effort of staff or the beautiful conversations that did happen that were good. It's just saying, hey, if you end up in a position where you have not one tribe, but 4 tribes coming to your table and saying, hey, you didn't quite get that right, maybe we didn't get it right. And so I want there to be deliberation and discussion about this, but I'm also happy to make a motion. So,
well, just if I could just respond. Just 1 second, Commissioner King. I think there are legitimate ways. I get your points. They're well taken. I think there are legitimate ways to look at this that are quite different. And I don't think it's just waving our hands at it to say that we have an obligation to figure out how to do these MOAs better in the future. To me, that's the lesser of 2 evils. The bigger one the one that would be even more troubling to me is to take away an MOA from somebody who has been doing well under it for 2 years because there are objections and the objections are legitimate. They're a very big deal. I just think it doesn't seem fair at all to do that. It seems fair to me to create, and I get the thing that, we were rushed or whatever, but I give it a little more credence than that. I think it was a good decision.
We aren't taking it away. So the MOA stays in place and we have the opportunity to give this a little more space. And that's what it does. The MOA doesn't go away. These beautiful stories that we heard this morning that are very important about people getting to go fishing and hunting. Those stories were those stories were good. I'm sure the whole room felt those stories were good. When I went over to coffee, there were a couple people just kind of talking to each other across this divide, saying, why are we doing this? Why would we do this? We just haven't given this some space.
Yeah.
Right? Like you all are going to be together for the next, probably longer than, I mean, let's work together, people. Why wouldn't we? So that's where I land on it. Maybe we're getting to the same thing in a different way, but that's what I think. And I will make a motion in a minute.
Okay, we have Commissioner King who would like to say something, and also Commissioner Labhart, and it looks like Commissioner Spellbrink. So go ahead, Commissioner King.
Thank you, Chair Wall. No, I would agree. The only way, at least for me, moving forward, looking at all of that I've examined, heard, seen, what we went through a couple of years ago. The only thing, is the fact that whichever way we vote, we are not taking away an MOA. That's the thing. That is the crux of understanding here. We're not taking one away. Like, maybe we need to edit, modify it, or do something to it, but we're not rescinding something. We're not revoking something. So that, I thought, gave me a bit more hope as I learned more, and that's some of the questions that I asked in executive session, to make sure that was clear. And also, I think I don't think we did it in any of the 5 MOAs that we created, but maybe that's something to consider as we move forward with this one, and as we move forward with reviews, is bringing in the expertise of the social scientists, like I'm forgetting her name, but she's at Oregon State. She's a PhD, Dr. something something. I remember she knows Kathy Yoon. But bringing in people like that, bringing in that human dimension, like, how do we get to common language? How do we get to some understanding? Because so much of what's at loggerheads is just that, it's apples and oranges, it's chalk and cheese. Like, we've got to get past so much of that stuff before we can come to some of this other language. So I'm wondering if, by bringing in some of those aspects as we get the second go round, like if we bring in some more aspects, because one of the things that is quite clear, even though, yes, we are making decisions about fish and wildlife of the state, we're also making decisions about humans. And this is so deeply connected and so intertwined, and we have tried to silo it in our colonialized Western culture, and so many other cultures don't. And so, like, that's something that we need to kind of come to grips with and be able to talk about to each other better. So maybe bringing some of those aspects into, and this would give us a chance to bring some of those aspects. And again, knowing that it's take time. The only way is through. So that's where I'd leave it.
Thank you, Dr. King. Let's go to Commissioner Labhart and then Commissioner Spellbrink, and then we will come back to you, Vice Chair.
Okay, so let me try this. So if we went ahead and accepted the petition and directed staff to start through the process, probably, I'm going to look at Director Colbert, but minimum a year, right? Before we would get to something. The way workloads are, it takes 3 months just to do the OAR legally. So that's 3 months right there, guaranteed. And then to work through something, it's going to take a while.
You're right about the 49 days minimum, but I really would be hesitant to even guess.
Okay,
the time.
So it's fair to say it's going to take a while. So let's say it takes a year. So we're already 2 years in with the MOA. Another year would be 3 years in. So one option would be for the petitioners, for the attorneys to say, well, we're willing to wait the 5 years and let's evaluate it and see how it works. And if the fears we think are happening, great, we can revisit it. If the fears are not happening, great, we can leave it as is. So that's one option. The other option is to go through the process and get a commitment, or open up the rule and get a commitment from the tribes, and it only is going to take probably one of them, and to say, if all the tribes would say, we're willing to give it one more shot. We did it, we paused it once and got a modification. We had 3 meetings where we didn't get anywhere, and we're now 2 years in. Are the tribes willing to say, we're willing to have more discussions about this, as Commissioner Hatfield-Hyde says, we're willing to have more discussions about this to see, even though we couldn't get there on the 3 and the 1, we're willing to have a discussion to see if there's some kind of ground that we can both, it's not perfect, but we can walk away and say, we can live with that. So I don't know if I'm a judge sitting here and there's the attorneys out there. Attorneys, are you willing to agree to something like that? Are you willing to sit around the table and see if there's one more time to do what Commissioner Hatfield-Hyde says, is to do some more consultation and try to do this? Or are you saying, nope, we're done. We're going to win or lose, and then if we lose, we'll maybe see you in court. If we win, great. So if there's a head nod from Grand Ronde, are you willing to revisit just to have a consultation one more time?
I'm not
Can we do that?
Commissioner Labhart, I'm not sure that it's fair to ask people to answer that without the chance to talk to.
I guess we can try to guess. My worry is that we've already failed.
I'm going to just say that I'm not sure that people would have time to even think that through. So good question, but wait, one other. Bob, did you, Commissioner Spellberg?
No, I was just also going to respond to the fact that MOA, no matter what we do here, the MOA doesn't disappear. I know one of the things I was thinking also when I read all the petition and the responses was when I saw that, we're only 3 years away basically from looking at it might take us 3 years to get to a point to where we can come up with something, maybe it'll all work out. Anyway.
Good point. It may not be very satisfactory to people on the other end, but yeah. Commissioner Hatfield-Hyde, you look like you're ready to.
Yes.
Could you put yourself?
I move to accept the petition and direct the department to initiate rulemaking to repeal or amend OAR 635-800-0300.
I'll second it.
It's been moved and doubly seconded that we accept the petitions.
I can't hear you. Mike?
Someday I'll learn that. It's been moved and seconded to accept the petitions and direct the department to initiate rulemaking to repeal or amend OAR 635-800-0300. We'll take a voice vote on this.
Discussion?
More discussion?
Yep.
Okay, go ahead.
It's legal to.
Yes, it is.
So I'm going to probably vote for it. And what I'm going to vote for it is I'm going to assume the best here. I'm going to assume that the tribes will get together and try to fix this. The MOA stays in place until we get the process going, which will probably be a year. But maybe you can work something out. If you don't, then we have to make that decision whether we accept the rule or not accept the rule. So you got one more bite at the apple if you don't like it or you like it. So it's not like it's dead. It still moves forward. We can accept the rule or not accept the rule or move ahead with the process. So I'm begging you, tribes, get together and see if you can work this out and don't make us have to do this again. So something that you can live with. So.
Would anybody else like to make a statement before they vote?
Yeah, just briefly. Can you hear me?
Go ahead.
In support of Commissioner Labhart, I hear the desperation in his voice, and I understand it. I agree. This is an awful place to put us in as a commission, as a state agency, to be in the middle of sovereigns. Yeah, I see you shaking your head, Vice. I mean, it's wrong. It's wrong. And if we can find a way to right this wrong, even with, with this new, whatever they're called, this task force coming onto line, like the governor's office, help us and give us more assistance or just something, because every state agency is going to struggle with this. And it's just not the place, in my humble opinion, this is not the place of state agencies to be in the middle of sovereigns. So we've got to find a better way through. I keep saying it because we've got to find it. So I hear the desperation in your voice. I share it. because it makes me queasy that we're making these decisions about sovereign nations. And it's just like, who are we exactly? It makes you feel a little bit awful. So here's hoping we find that way through. And here's hoping that this gives another chance for that to happen. Well, maybe other things come into maturity that assist us in that matter.
Thank you, Commissioner King. Commissioner Hatfield Hyde.
And one more comment to the comment to the comment. I would also want to say to the room that it's not about looking at you all and being like, hey, fix it, right? We were the ones that put you in this place. We did this by moving too fast, by passing something when it wasn't ripe, by not consulting with all of the affected tribes. We did this. It's not about you all go fix it. This is a mess that we created, and I'm sorry.
Just to go back to my comments earlier, I find myself still not wanting to accept the petitions because I think that these things have to be as fair as they possibly can, and that doesn't seem fair to me. And so I will be voting no on this one. I think we should deny the motion and figure out what to do on these on the future ones, not put it on to this one. So let's go ahead, and I appreciate everybody. I still am, I will accept any kind of blame people want to put on the commission, but let's move forward and go from there. So Michelle, will you call the roll, please?
Labhart?
I'm going to vote no.
Can I have you turn your microphone off? DeFries?
Yes.
King?
Yes.
Spellbrink?
Yes.
Hatfield Hyde?
Yes.
Wall?
No. Motion carries. Thank you all.
Oh, shit.